compelling circumstances, I am mentioning one matter for upgradation. The item number 1385 of monthly list. Urgency is about the unauthorized construction made by the private respondents. Due to that unauthorized construction, today the entire the ingress and exit has been blocked. In the today the situation is the water flow has been going to my house. I cannot reside in the if I lost kindly upgrade it. So
For ingress ingress, you should approach the civil court. For unauthorized construction,
unauthorized construction. Unauthorized construction. Grateful.
Give your slip.
Well, may I have a lordship kindly? Well, mentioning under compelling circumstances, well, my client well, is an employee with Bhatpada municipality, the scheduled tribe candidate. Well, we have filed this writ petition well, seeking consideration of my promotional post. Well, this what the well,
Give your slip.
well, this is for upgradation 115.
Mention for upgradation,
Yes.
lordship, or is the side matter for order correction, lordship, to be mentioned.
Order correction.
Yes, lordship.
May I have your lordship?
ये original side है, Manoj.
May I have your lordship kind leave to mention mallet for upgradation mallet monthly list item number
Give your
2324.
slip. Give your slip.
Lordship, may I be permitted to mention one matter of your lordship's combined list 2641, my lord. My lord, may I, my lord, kindly, my lord, upgrade this matter because under compelling.
Give your slip. We'll see that.
Lordship, I'm ready.
For withdrawal matters.
Withdrawal.
Lordship, may I be permitted to mention for upgradation?
Give your slip.
Lordship, just one thing I have to mention. That is, I have already mentioned this matter in previous week, where your Lordship was pleased to consider this application.
Madam, only if we find there is a ground for upgradation, we'll upgrade. Otherwise, keep mentioning, keep trying your luck.
Lordship, the urgency is
We'll see the urgency. Give this slip.
Lordship. Obliged to Lordship.
What is the ground? Where have you mentioned the ground? That is the reason it will never be upgraded.
I shall write it, your Lordship.
Why should it get upgraded?
Lordship, the
Periodically, this court has been asking you to mention the grounds of urgency. If this is how you are going to mention and then say this matter is not getting upgraded, why should it get upgraded, madam? Tell me with this.
my apology, your Lordship.
Where is the ground? Not even a word, whisper about any urgency. And then you are saying, I've mentioned it last week. It was not upgraded. Why should it be upgraded? Tell me one reason.
I shall write it. your
Without
Lordship.
any ground, how will this court know? And then you are complaining the matters are not getting upgraded. And you have mentioned twice. This is how you mention. Without any ground. This will never be upgraded. Why should it be upgraded?
My apology, your Lordship. I shall write the reason and submit it.
Obviously, then only this court can see what is the ground of urgency, madam.
Lordship. Obliged.
Call out the list.
Item number 1.
Non-prosecution, they want to withdraw it. Not something. Is determination क्या है? Police in action. Not today. Not today. कल के लिए कर. See, these are upgraded matters and nobody comes. At the time of mentioning, you have 50 lawyers standing here. Good morning. The impression is given as if this court doesn't want to upgrade matters. And when we upgrade matters, nobody. Not today.
Leave to withdraw.
This is also upgraded matter.
No, my lord.
Then?
Leave to withdraw, my lord.
No, I know, but on mentioning it's listed or on its own it's listed? On mentioning, right? That's what I'm saying. On mentioning matters are listed and nobody comes. At least you have come.
Corporation.
Learned counsel for the petitioner states that he has received his instructions from his client not to pursue with the presented petition. Full stop. Copy of the instruction is taken on record. The presented petition is dismissed as withdrawn.
Corporation is also represented. Corporation is also represented.
Yes, yes. Give your appearance.
One. Give. Like that. Office call.
Well, I am on behalf of the private respondent.
I beg to appear for the petitioner.
My lord, Mr. Bandopadhyay, Shishana Bandopadhyay is appearing for the corporation, my lord, from item number 4 to 6, my lord.
Right.
Just a short pass over, my lord. Praying for a short pass over.
My lord, I am filing the reply, my lord. I am filing the reply to the opposition given by the corporation, my lord.
What is the matter?
Relating to the unauthorized construction,
The matter is
Well,
that
the demolition order has been stayed by the order dated 23rd September 2024. Thereafter, the matter was in terms of the everybody has already exchanged. Now the matter is ready for hearing. Now the
my lord, it is the matter, my lord, when the, my lord, the petitioner is fighting for the protection of the matrimonial home. And my lord, the daughter of the land, my lord, is trying to gauge the land for the cattle, my lord.
We are
My lord,
not
the-
concerned with that. We are only
lord,
concerned with the unauthorized
this is-
construction.
My lord, this is the second order of demolition, my lord. When the first order of demolition has been set aside, my lord, on the findings, my lord, the corporations
the
have been found dealing with the
municipal corporation
private
is a
dispute, my
reply alleging that the unauthorized construction has been held.
my lord, this is the all along allegation, my lord, for encroachment, and that's why, my lord, the
Where
first
is Mr.
petition has been
Bandyopadhyay?
dismissed, my lord.
Lord, he's on his legs, my lord. A short pass over, my lord.
Have it on Monday.
My lord.
Monday, not today. Monday.
In the same hearing,
Uh,
Monday.
Affidavit in reply
Already submitted.
to the affidavit in opposition filed by the petitioner is taken on record. Let this matter be listed on Monday.
My lord, there is an interim order, my lord.
When is it expiring?
My lord, up to 2 weeks, my lord, on the last occasion, my lord. Perhaps, my lord, on Monday it will be expiring, my lord.
All right, we'll have it on Monday.
Yes.
Monday.
In the same position, my lord.
इसको ऊपर रखना vacant petition.
Not in the same position, my lord.
ये सुनो These are all connected, 4, 5, 6, right?
No, my lord, only four. My lord.
Only 4.
Only four, my lord.
My lord, item number 4, only 5, sir. Well, item number 5 and 6, my lord. In this matter, my lord, there is a direction for filing exception to the report, my lord. I am filing exception to the report. I have served the copy to the municipal authorities. My lord, this is, my lord, a matter, your lordship, your lordship kindly consider, in 2024, 6th of November 2024, I filed a writ application, and prior to that, on 4th of October 2024, I submitted representation that the private respondent 9, 8 and 9 are making.
Who's for the corporation? You are
My lord, respondent number 8 and 9 are making an illegal and unauthorized construction without any sanctioned building plan. In respect of my property, though this is the not subject matter whether my property or their property, and to that effect, civil suit is pending, and civil court also passed an order of injunction to that effect, that not to change the nature and character.
whatever arguments you are making, keep showing the documents also to that effect.
Right, your lordship. Shortly, my lord, I am making submission, my lord. Your lordship will find from the, there are 2 writ applications. In 2024, I filed writ application. When the writ application was pending, I mentioned before lordship, and your lordship was desired that if let them to make construction, I will see. And I served notice to them that I am mentioning the matter, your lordships, on several occasions. And during pendency of the matter, on 20th April 2024, granted prospectus building sanction permit. And in the second writ application, I have challenged that prospectus building permit is not permissible in respect of 8 and 9. And in respect of my lord 10 and 11, my lord, in the second writ application, they are not part of the first writ application. In the first, there is changed circumstances under competent circumstances challenging the prospectus sanction. I have to file the second writ application. You will also kindly consider the first writ application, my lord, second writ application. Page, you will also will find.
Yeah, item 1 में पहले लिख लेना. Exception.
Lordship, I am appearing for the state respondent, Lordship, in item number 6, Lordship, along with Piali Sengupta, Lordship. Lordship, I have put my name in my chat box, Lordship.
All right.
Your lordship,
Exception.
please.
This is you have filed in exception 5. Exception.
Lordship, we have
report.
already filed the police report, Lordship, in the earlier occasion.
Madam, please.
Lordship, Lordship.
Exception to the report filed by the respondent number 2 to 4 is taken on record. Yes.
And
Item 6 you are first relying on.
item number 5, I am relying. Writ
You
application
have challenged the post facto approval in which writ petition?
6, 2025.
You want me to see 6 first?
First.
Yes, tell me.
But page
This is writ petition number 26809.
Yes.
12394 of 2025.
This is then item 5.
5.
Yes. Yes.
Well, you will also kindly consider page 67. This is my first prayer before the municipal authority to look into the matter and to consider. But I am reading this. The undersigned and his other co-sharers being the heirs and legal representative of late Prafullo Kumar Mitro, the original recorded owner in this such and such properties, but I am reading that the apostate Shubhajit Ghosh and his mother, Ruma Ghosh, in they are respondent number 8 and 9. In most illegally are proceeding with the massive Pakka constructions in a portion of the apostate RSN LR plot number 253 by 459 and also in RSN LR plot number 254. Which is a Danga land and without sanction any building plan, also having no iota of title in this such and such. In the above circumstances, the undersigned being the lawful owner in respect of the aforesaid Danga landed property in such and such to hereby lodge this complaint with the request to stop such illegal and unauthorized construction made
constructions as made and is going on by the aforesaid Shubhajit Ghosh and his mother, Uma Ghosh, in the aforesaid plot of land in direct connivance with the local councillor. His mother, he is the respondent number 5. He is not appearing and he is not possibly contesting the matter. That is the main persons under in ward number 21. There are to take further steps to demolish this illegal and unlawful construction as made. The aforesaid Shubhajit Ghosh and his mother Uma Ghosh on this said Danga landed property, immediately failing which the undersigned shall be constrained to take steps before the court of law for their appropriate redressal and grievances. But thereafter, nothing steps have been taken. They are sitting idle over the matter. You will also find from the photographs. My lord, page 108. And these are all submitted before the municipal authority. No inquiry was made. No stop work notice has been issued. Nothing. As you also got it, there is a massive construction was going on. And next, my lord, page 109 also, the photographs. Then you lost.
They have got a building permit. On page 110, Uma Ghosh has got a building permit for construction.
Page, my lord, 110.
Yes,
My lord, on 24th of April 2025.
yes,
Construction started, construction commenced.
yes.
My lord, to that effect, my lord, kindly consider the section 261A of the Municipal Corporation Act.
Which act?
261A of the original Municipal Corporation Act. You must find.
This is- Yeah, यहाँ पे-
Consider
यहाँ पे-
261A.
Yeah.
261 starts.
इसको यार
use of land for
ये हटा के ना ये पूरा उठा के यहाँ डाल इसको रखना ये अच्छा है
Ojibon
Side
Municipal.
change.
Well, Ojibon Municipal Corporation Act 2006.
266.
261 first, you will also kindly consider. No person shall use.
Just a minute, just a minute.
All right.
261. No person shall use.
No
Yes.
person shall use any piece of land as site or for erection of new building, except in accordance with the provisions of this act and rules and regulations made thereunder in relation to such land or in erection 261A.
Hey, just
Prohibition of
just a minute. Yes.
the prohibition of building without sanction. No person shall erect or commence to erect any building. 261A. Building or execute any of the works specified in section 259 except such previous sanction of the commissioner and in accordance with the provisions of chapter and the rules and the regulations made thereunder in relation to such erection, building or execution work on payment of any such fees may be prescribed. Provided, my lord, this is the my lord 261A.
Yes.
Your lordship has found your lordship from, I have referred that building permit on 24th April to 20th April 2025. My lord, on 4th of October 2024, I submitted representation to the municipal authority with the photographs.
Yes.
And my lord, on 6th of November 2024, you will also kindly take note of the dates. On 6th of November 2024, I filed the writ application when the writ application was pending. The municipal authority, without making any inquiry, without causing any inquiry, my lord, granted the prospectus sanction on 24th of 20th April 2024, which is under challenge before lordship. Whether it is permissible or not, your lordship will consider and decide it. That is the short point in this matter involved in respect of respondent number 8 and 9. Now, your lordship has found already, and in spite of there are civil court injunction to that effect, not to change the nature and character of this property. And in the exception, I have enclosed, and in the writ application, I have also.
Sir, please show it rather than just making these verbal statements.
No, my lord, your lordship
Just take me to the documents. Will be more helpful for this court.
right. Your lordship will write. Your lordship will find kindly exception to my report. Your lordship will find page 21. I have enclosed the plain 1151 and 2024. And you will also find page 2022. Sorry, page 23 on 5th of October 2024. Initially, on 1st of October 2024, there was an order of injunction. That order was modified to that extent that defendants and their main agents hereby restrained from transferring of the suit property and to third party and from changing the nature and character. And you also will find the plain. In the plain, you will also find that respondent defendant number 7 was Shubhajit Ghosh, that is respondent number 8 hearing. Next, you will also find that in exception I have stated categorically the municipal authority submitted my, you will also kindly report, you will also kindly consider the report there. Report, nothing has been considered in the in my writ application that whether it is a post facto or not post facto. You will also kindly only, my lord, they have stated, my lord, you will also find no inquiry has been made. Paragraph 3. Upon perusal of the official record, it transpires that a building permit such and such was sanctioned by Bidhannagar Municipal Corporation on 20th April 2025 in favor of Srimati Uma Ghosh for the proposed construction of a two-story residential building.
The allegation is
This is the only, my lord, consideration. But in my writ application, I have stated that even the violating the building permit, that residential building, your lordship find post facto sanction, your lordship, I have placed before your lordship that post facto sanction in respect of a residential building, but to construct a commercial unit, shop rooms, and in respect of this properties in question, that is the subject matter of the civil court, and civil court will decide it. But in respect of construction, we have made prayer before the municipal authority on 4th of October 2024. This is the total report, nothing consideration in respect of my writ application, in respect of my representation, nothing reflected from the report. Only they are supporting such illegal construction is a right construction. And there is no consideration about post facto. This is my prayer in the writ petition, in the entire apartment in the writ application post facto sanction. Now, also can you consider in my writ application, I have specifically stated regarding post facto sanction, I have specifically stated, you will also find paragraph you will also find I am reading paragraph 20. The petitioner states that the petitioner for the apostate illegal has your lordship.
Page 23, my lord.
He will not tell me the page also. He will only tell me the paragraph.
Page 23, paragraph 20.
Thank you.
May I read, my lord?
Yes.
The petitioner says the petitioner for the aforesaid illegal acts of the respondent number 8 and 9 in making construction of pakka shop rooms in plot number 253 by 459 without any sanctioned building plan. Submitted several representations to the Dismissal Municipal Corporation who are made respondent number 2, 3, 4 and 5 herein. And for not getting any justice from their end, the petitioner filed WPA number 26809 of 2024. Before this honorable court, which is pending and running in the list of His Lordship Honorable Justice Gaurang Khan, and during pendency of this said petition, the aforesaid private respondent 8 and 9 succeeded to complete the construction of several shop rooms, and the said private respondent Uma Ghosh, the mother of the Subhajit Ghosh, in direct collusion with the local councillor and commissioner, Dismissal Municipal Corporation, succeeded to obtain post facto building permit on 2025 in respect of a dwelling unit for residential purpose, and the said respondent has almost completed several number of shop rooms at the indulgence of the municipal authorities in spite of subsequent letter of complaint of the petitioner on 21st of April 2025 and 22nd of April 2025. And prior to that, there are several complaints with regard to the illegal and unlawful construction which have also been closed in the present writ application and also earlier writ application. It is submitted that the respondent municipal authorities colluded with the private respondent, and the said municipal authorities shutting their eyes knowing very well that proposition of law that no post facto sanction can be given when the private respondent already commenced construction before submitting his arrears building plan in plot number 254 low. The said construction is made in plot number 253 by 459, and the municipal authority, in spite of receipt of several complaints from the petitioner, did not bother even to make an inquiry to hear out and consider the written representation of the petitioner, and such acts of the said municipal authorities are entirely illegal. Well, the copy of the arrears collusive report, the post facto building permit for the residential building in the name of respondent number 9, Uma Ghosh, dated 20th April 2025, along with photocopy printout photographs showing incomplete construction of shop rooms in plot number 253 by 459, and also part of such construction on the government land. On the government land also they have enclosed, and there is no consideration in the report as being enclosed and marked in annexure P and P9 and P10 collectively the copy of the letter of representation that such and such. Now, Lordship, kindly consider the photographs you will find, subsequent photographs you will find. There are subsequent photographs after post facto permit you will find right from page 111 starts.
Page 108, you are saying are pictures from, where is the date on the pictures?
Post facto sanction.
Date chahiye just.
Other than date, I have mentioned that after.
Where is the picture on the dates on the picture? How do you say that these pictures are before the sanction?
If that not be so, then before that, in the earlier writ application, I have stated the photographs I have enclosed.
Where is in the other petition pictures are there?
I have enclosed.
The dates are there on the picture?
I have not mentioned. My client has taken the photographs. That's why, my lord.
These days, every camera has a digital.
Right, your Lordship, perfectly right.
Where are the pictures on the next?
In the earlier writ application, Lordship.
It's the same pictures, sir. Where are the dates mentioned? It's the same pictures.
And in earlier writ application, Lordship finds the photograph.
Page 90. Where are the dates for the pictures? When you are saying that this is a post facto approval given, how do you establish that the construction was there before?
In 2024, when I filed the writ application on 6th of November.
So where are the pictures, sir?
When I filed, then before that 6th of November.
That's what I'm asking. What evidence, what proof you have to substantiate your...
I am putting the question myself. In 2024, 6th of November, I have filed writ application, and before grant of the building permit.
All right.
then my lord, it may presume, my lord, that photographs not
We
after,
don't go by presumption, sir. We
No.
go by evidence.
not after 2024.
Your pictures don't reflect any date on it.
No, not date, my lord. Before 6th of November, these photographs have been taken.
How do I know?
My lord,
Where is the date on the picture?
on 6th of November, I have filed the writ application.
Yes, you have filed it. Where are the dates? What pictures are these? Of the
Right.
same building, not building, how do you know?
You're actually perfectly right. What is the?
Where is the, did you carry a newspaper in front of the picture? How do you take pictures, sir?
Your
For
lordship,
prove a date, how do you, suppose your camera doesn't have it,
your lordship,
how do you prove the date?
in-
You stand there with a newspaper of that day.
in my representation on 4th of October, we have stated an oath. They are not denying. They are in the report. They are not. There is no reflection that are not. For 4th of October 2024, they have made anything.
Okay.
On 4th of October, I have submitted representations, stating details that they have made construction and construction is going on. There is no consideration to that effect till date. And then when I have been compelled to file the second writ application. In this second writ application, I have enclosed the further photographs.
The photographs are the same.
No, page,
Page 108.
114, that 111, 114. You also find 114. Then you also find
Same photo.
right from 110 onwards. You also find they are not same photographs. 112.
What is 113, sir?
uh,
And what is 114, sir?
100
These are shops
114
which look are old shops which have been constructed.
No, these are not the subject matter. I have stated in my writ application, there are several
I'm
other.
asking you a question, sir. When you are showing me 114, what are these pictures? Can you please tell me?
No, in my, but why I have enclosed, in my writ application, I have stated that there are other persons are making construction in ward number 21 without any sanctioned building plan.
Sir, that's what I'm asking you from page 114. What are you showing?
No, I am not, you also can ignore it, 114. You also can consider the 112.
All right. 112 is the same picture which is on 108. It is the same picture which is on page 90. There is no difference
No.
between these three pictures, sir.
108, then the construction of Sopon has not been, roof casting has not been completed. And 111, you will also find that 112, you will also find that roof casting has been completed, shutter door has been fixed.
Sir, where are the shutters fixed, sir? 112.
Yes, you will also find the shutter doors.
I don't see any shutters being fixed, sir.
You will also find the shutter doors. At my cost, you will also can.
Where are the shutters, sir? Where do you see it which I can't see it?
These are all shutter doors, my lord. 1, 2, 3, 4.
The
Four-
same picture as 108, the same picture as page.
108, when commenced the construction
Oh, all right,
in 2024.
all right. What else?
Next, my lord, you will also find that well, you will also kindly, if my statement is not, my lord, you will also do not accept, you will also kindly appoint any special officer to ascertain whether they have enclosed the road or not, or
Where is the allegation that they have encroached upon the road?
yes, I have, my lord, already, my lord.
So your allegations are construction on government land, encroachment,
Yes, my lord.
post facto, what else?
Now you will find
Page 25. Sir, I have understood your argument. Your argument is post facto approval,
yes.
encroachment on government land. What else? Anything else?
But further, my lord, I have argued your lordship, my clear your lordship, that in 2024 only matter was pending.
That you have already argued post facto approval.
And to that effect, my lord, I use, and my lord, and my lord, another point, my lord, I will argue that in our honorable court, my lord, decided the issue that I have stated that in plot number 254 is an undivided property, unpartitioned property. In an unpartitioned property, no person can make any construction. Our High Court decided this issue.
Got
The three judgments I shall cite.
Give the judgments.
And my lord, in the report, I am challenged the report, I have stated that this is a policy report and no consideration in my writ application.
Yes.
Firstly, my lord, I am submitting the division bench judgment of our honorable court, my lord. This is post facto sanction. Mat 1025 of 2022.
5 of 2022.
20?
22.
पे लिखा करो ऊपर मेक yes
My lord, you also can in paragraph 8.
yes sir
It has been argued that the decisions reported in 1986, volume 1, SCC, page 264, relating to the foreign exchange regulation and section 29(1) of the said act emphasizes that permissions of Reserve Bank of India may be given ex post facto for the economic interest and the country, and there is no bar for granting ex post facto permission if applied earlier. According to him, the undersigned the West Bengal Panchayat Act 1973 of West Bengal Gram Panchayat Act rules 2004. There is no scope for grant of post facto sanction to the illegal and unauthorized construction under any circumstances, and no prior application was made by the petitioner before construction. According to the learned counsel for the council, in the decision reported in 2021, volume 10, SCC page 1, the court observed that an unauthorized construction destroys the concept of planned development and places of unbearable burden on the basic amenities provided by the public authorities. The court further held that it was imperative for the public authority and to not only demolish such construction but also impose penalty for the wrongdoers involved admittedly according to the learned counsel. This instant appeal of the appellant has not been has not only constructed building and other structures without permission sanctioned under the West Bengal Panchayat Act 1973, but also violated the provisions of the Land Reforms Act 1955. And thus the petitioner should be penalized. Next, you will also find paragraph 9. The learned advocate Mr. Dotto, appearing for the respondent number 8, being the Pradhan, Mednipur Gram Panchayat, Onda, district Bakura, submitted that though the appellant challenged the memo number such and such issued by the Pradhan of Mednipur Gram Panchayat, Onda, district Bakura, and the order dated 10th of March 2022 passed by sub-divisional officer, she did not challenge the order dated such and such passed by the respondent number 8. And as such, the order is still subsisting and enforceable as on today. Section 23 of the Panchayat Act 1970 speaks that no person shall erect or new structure or new building or make any additional structure or building in any area within the jurisdiction of the Gram Panchayat, except with the previous permission in writing Gram Panchayat. Upon reading of the provision, it is found that the said provisions has been couched in a negative term, and in view of this such negative comment, the provision of section appears to mandatory in nature. The support such and such contingent reliance has been placed in the decision reported in 2019 volume 9 SCC, paragraph 17. It also appears from the said provision that the phrase previous permission, as mentioned therein, goes to show that the word permission is being qualified by the word previous, and therefore it can be construed that taking prior permission in the intention of the legislature and such the same is sine qua non with a view to buttress the aforesaid submission. Reliance has been placed upon a decision reported in 2010 volume 3 SCC, paragraph 12 and 15. In the aforesaid decision, it has been laid down that if there is any prefix to the aforesaid words either as prior to previous, it is mandatory on the part of the statutory authority to take such approval and permission before action is taken. With a view to draw an analogy, Section 392 of the Kolkata Municipal Corporation Act 1980 was referred to. That the said provisions of the Act of 1980 is similarly worded, and in the identical issue came up for consideration before the learned single bench. In the matter of Lipika Das versus KMC, reported in 2012 CHN Calcutta 65, it has categorically observed that the post facto sanction is against the legislature mandate contained in section 392, 393 of the said Act of 1980. Therefore, post facto sanction as sought for the appellant is contrary to the statutory mandate, as emphasized in section 23 of the Panchayat Act. Accordingly, the learned counsel argued that the provisions of Gram Panchayat Act shall be subject to the rules, and therefore the respondent number 8 is under the authority and obligation to follow the procedural provisions as enumerated under section 17, 23, 24, 26, 27 of the Gram Panchayat Act, Gram Panchayat Administration Rules 2004. In the instant case, admittedly, the appellant never filed application in the prescribed format, disclosing material particulars as required to be furnished in consonance with the rules of 2024. Next, my lord, you will also find I'm not reading the entire, you will also find paragraph 27.
Yes.
The last paragraph 20, page 24, paragraph 27, last line. Therefore, the law and the rules are very much clear to the effect that before constructing a building or part of thereof, it is to the duty of the concerned person to show that the proposed construction is accordance with the settled parameters, submitting a plan, proposed structures, and also recorded the rights and other records showing the title and interest of the applicant in respect of the land on which the applicant proposed to construction. It goes to show that before granting any sanction, any proposed plan, the panchayat or competent authority has authority to ascertain by going through the documents with whether the applicant was able to establish primarily his or her right, title, interest in the property. The duty of the panchayat also extends to scrutinizing verifying the structural stability and the proposed construction, as well as the fact that the construction would be injured or impede the construction of the neighboring people. The bounden duty, this is important, the bounden duty cast upon the applicant to submit the necessary documents can be overlooked by saying that Gram Panchayat can grant ex post facto sanction if construction has been made without sanction is in accordance with the parameters of the construction rules. It is unfortunate that the applicant did not submit the requisite plan, construction or other documents showing title such as. My lord, you will also find that next you will also paragraph 29 also, I am not reading that regarding post facto, could consider it, and lastly you will also find paragraph 35. Considering all the aspects, I do not think there is no need for interfering with the order passed by the single bench, as well as the order passed by the subdivision officer Bakura. a criminal proceedings, here a criminal proceedings is pending against them. We have lost complaint with the police authority, and police authority started a FIR. That FIR is pending. Converting the same into the Vastu land and without obtaining permission from the competent authority, the criminal proceedings will take its own course. The civil courts of the district should not be influenced by any observation made above. Here is civil suit pending. Criminal already police started an FIR in 2024. And from the police report, you will also find possibly if the police submitted the report to that effect. That is the FIR to 2024. And in the FIR, for police authority, my lord, after considering my complaint,
Is it on record?
FIR.
Whatever you are saying, is it on record?
In the
Statements which you are making, sir, is it on record?
I have mentioned in my read application, I have also enclosed.
Show it, sir.
I am showing.
Page 103 is the FIR, man. Page 103. There are two page numbers, 85, 103.
My lord, page page 103, on the basis of my complaint dated 29th of October 2024. My handwritten copy are enclosed and a type copy also enclosed, my lord, page 104. And they are on bail. On the basis of my complaint, you will also find type copy 104. And from the report, you will also find everything has been done 2025. Application submitted on January 2025 and conversion also made in 2025. And my lord, when the matter was pending, we will also, my lord, they, without taking any leave also from this honorable court, my lord, they granted sanction on 20th April 2025. Next judgment I am citing your lordship. This is single bench judgment your lordship will find. One 483 of 2023. Regarding prospective, you will also find paragraph 9. Paragraph 8 first, you will also find.
divided by 6.
Paragraph, I am reading paragraph 4 at page 4. Admittedly, when the order was passed on January 4, 2023, directing the Panchayat Authority to look into the representation of the petition with regard to the allegation of unauthorized construction of the respondent number 8 and 9. The plan had not been sanctioned. Even at the time of inspection, Gram Panchayat found that the plan has been prepared but not sanctioned. Next, the question of prospective sanction does not arise, as the law does not provide for either regularization or unauthorized construction of Gram Panchayat after the building has been completed. Even at the inspection, the authority found that there were documents showing that the plan has been prepared and the case where the seal. Next, your lordship find paragraph 8. Paragraph 8. An interpretation has been given by the provision, we have last got it, my lord.
Yes.
And interpretation has been given. The provisions of law, like section 23(1) of the 1973 Act, which will discourage people from taking law into their own hands and dissuade them from putting up construction without obtaining prior sanction of the concerned authority. A building constructed in violations of the provisions of section 23(1) must held to be illegal and unauthorized and incapable of being regularized. Section 23(1) as permitted by the Panchayat in accordance post facto sanction. The same is also to lead show of money power and corruption. Next, you will also find last paragraph. If the prayer for the petitioner for post facto sanction is allowed, nobody will care the law and apply for obtaining sanction prior it is to be nipped in the bud. Otherwise, the rule of law cannot be applied, though ought not to be different such and such. And paragraph, my lord, 9 also, my lord. I am not reading that. Your lordship has already read this paragraph 9. This is regarding post facto, my lord, your lordship. And my writ application, my lord, I have also taken another ground that 254 is a chunk of property, which was more or less 10 point something acres of land, and wherein I got my share also, my lord, 1.110 acres presently, and this land was, my lord, there is no partition under the provisions of section 14 of the West Bengal Land Reforms Act by meets and bounds, but there is no document is forthcoming, your lordship. That is a big plot, and where my share, I have enclosed my record of rights.
Yes.
Your lordship will find that this judgment also speaks about, this is honorable, this is our coordinated judgment, your lordship will find. WPA 2147 of 2022.
Yes.
This judgment has, you also has read this judgment.
Yes.
There is no consideration in the report that how they make how they make construction on an undivided property.
Yes.
And whether regarding the civil court dispute, your lordship in the judgment of the honorable division bench already held, there are other judgment of the division bench. When civil court matter is pending regarding title, the court will see the title and everything. Now, your lordship kindly consider in respect of my lord respondent number 10 and 11. There is no consideration in the report. In my writ application, we have specifically stated regarding 10 and 11, your lordship find paragraph, my lord, 2022, page, my lord, 27, that the petitioner says that the entire acts of, as you also got it, my lord,
Yes.
regarding respondent number 10 and 11, that the petitioner says that the entire acts of the respondent, particular respondent, municipal authorities, and police authorities, respondent number 2, 3, 6, and 7, are wholly illegal, arbitrary, malafide, and unconstitutional, and violations to the principles of natural justice, and those respondents are shutting their eyes over the aforesaid illegal acts of the private respondents 8, 9, who have already almost completed the construction of shop rooms in the shoot plot. Those respondents are further threatening the petitioner, who is an old senior citizen, being a school teacher, and peace-loving and law-abiding citizen, who also knocked the door of the court of law. And private respondents are further threatening the petitioner to implicate the false criminal cases and the petitioner for the time being for an inaction on part of the municipal commissioner for granting post facto sanction of his residential building plan of the building permit number such and such annexure P9. Here too, and further acts of the said respondent for not taking steps against the private respondent that has not been, my lord, type, my lord, to demolish the arranged construction of shop rooms in the shoot plot as shown in the photographs, and further petitioner on being abused by the respondent, particularly private respondent 1011, who are also making illegal and massive construction in plot number 254, which is totally unpartitioned solid plot of land, and the petitioner and another procedural got their moiety shares has been compelled to file the present writ application on subsequent cause of action, firstly for granting post facto sanction of the building plan in favor of respondent number 9, Uma Ghosh, and also for not taking any steps against private respondent number 10 and 11, who are making illegal and unlawful construction without sanctioned building plan. Next, my lord, your lordship will find regarding cause of action you have stated, and paragraph 23 also have I have stated regarding respondent number 10 and 11. Then you will also find from paragraph page 37. I have disclosed everything, my lord. You will also find the earlier writ application, earlier writ petition against the respondent number 10 and 11. And your lordship directed the municipal authority to submit a report in the form of affidavit. They have submitted the alleged report, but in the alleged report there is no reflection against respondent number 10 and 11. And my lord, there is no consideration in respect of my earlier writ petition, which is pending before filing this writ application. These are the total scenario I have submitted to your lordship. Now your lordship is considering the report and the writ application also. And you will also find that my submission that this the building permit of the alleged sanction without any inquiry, without making any inquiry, without taking any step, without hearing me. When I am in the I am before the court of law and before the municipal authority, and it is the totally violation of the principles of natural justice. When my representation are pending, and I am filing writ application for not considering the representation. And I have mentioned your lordship desired, or it is the lordship view that no upgradation, that at the time of hearing I will see if the construction made, I will take steps. That is my whole submission, your lordship.
You are appearing for?
Respondent number 10 and 11.
You are
For the corporation.
you are for the corporation. Your report doesn't show whether this was a post facto approval or not.
Will kindly takes the page, my lord,
Report,
page 6 of the report. My lord, in the middle of the page,
Yes.
the row which starts with decision. In view of the above proposed building plan, in handwriting, my lord, it is written 6 times sanction fees. So originally the application for a sanction building plan fees would be, my lord, 13,616. Now since, my lord, the application, my lord, was made on, my lord,
7th of December, my lord, 2020. I'm sorry, my lord.
7/2020.
না application sanction plan application টা কবে দিয়েছিল?
29 January.
I'm sorry, my lord. See, application for my lord obtaining a sanction building plan was made on 7th of December 2024. Now, my lord, section 262A of the Act speaks about, my lord, modalities as to how a building plan would be obtained, which is clearly, my lord, through online process. Now, my lord, the person responsible for the construction has applied online on 7th of December. Now, my lord, what I understand from my learned friends, my lord, submission that there is a allegation of post facto approval. He started constructing the building, thereafter, my lord, applied for a sanction building plan.
Can
That-
anybody do that?
My lord, that is the reason, my lord. This is a demolition building plan. 6 times fees of the normal fees has been taken.
What do you mean demolition?
Demolition, what I am told by my officers, my lord, is that once the person starts making a construction,
Nobody can make
nobody
any
can make,
construction.
it ought to have been demolished, my lord.
Yes.
It is presumed that the building has been demolished. Thereafter, my lord, the plan has.
There's no presumption in demolition.
My lord, this is what I have been, my lord, instructed, my lord. If your lordship desires, my lord, I shall, my lord, come back at 2 p.m. with clear instruction, my lord, because on telephone I have received the instruction, my lord. Your
There is
lordship,
nothing like presumed
my lord,
demolition.
I understand, my lord. I ought to have been, my lord, come with a clear instruction, my lord. Since this has cropped up in course of the submission, my lord, I have, as best as
It has
possible,
not
my lord.
cropped up in the course of submission.
Lord,
The entire case is post facto
my lord, my
approval.
lord.
Your report doesn't have a word about post facto
My lord,
approval.
my lord, I shall, my lord, take necessary instruction, my lord, why 6 times fees has been taken and what is the exact definition of demolition building plan that has
6
followed.
time fees would mean that you have given a post facto approval,
My lord, my lord,
which you could not.
my lord.
You show me the law. Under
Lord,
which law can you
my
give
lord,
post
At
facto
2
approval?
p.m. may I come, my lord?
Come at 2 p.m.
My lord.
Hello, with regard to 10 and 11, may I make submission at 2 p.m.?
2 p.m.
There's no allegation of post facto sanction against me at all. And
Who
there's
are
no-
you?
10 and 11 respondent number.
You are constructing.
I have a sanction plan. I have filed a vacating application. My sanction plan is of prior. I have constructed according to it. There's no prayer in the writ petition. May I just point out certain things, my lord? Or may I come back at 2 as well?
Come at 2.
My lord, may I pray one thing, my lord? All the things. Or at 2 p.m.
Come back.
May I deeply apologize, your lordship. We are very grateful to your lordship.
Actually, I am appearing for the petitioner.
My lord, I am appearing on behalf of the Chandanagar Municipal Corporation. I have got the private response.
Lordship, before your lordship takes up the matter, lordship, on the last occasion, your lordship has directed us to file a translated copy of the representations and the vernacular, the documents placed in vernaculars, lordship. We have translated those copies, lordship. May I just pray that we may file those translated copy by way of a supplementary affidavit. And also, lordship, may I just indicate on 8th of August, my client has received a notice for demolition of the unauthorized construction. It is also in vernacular, lordship. If I may, I am praying, lordship, if I may come back with a type copy of this demolition.
What your
notice.
client wants on a demolition of the unauthorized
Demolition
construction.
or
So
lordship,
they are acting on it.
lordship, they have, but I want that order to be implemented, lordship.
Now, my lord,
That they will implement. We can give a direction to them.
May I just come back, lordship?
Why? We can finish it off. Why do you want to come back?
Lordship, because otherwise, if they might
What
not.
is your writ petition, sir? Your writ petition is that you want them to take action on the unauthorized construction being raised at holding number 306,
Lordship,
right?
Lordship, my prayer B of the writ petition at page 10.
Correct.
Okay.
Now they have already initiated proceedings.
They have.
So your writ petition is stand satisfied. We will give a
Lordship.
direction that they will complete the process in accordance with law as expeditiously as possible. Writ petition disposed of.
and my lord,
The petitioner.
my lord, only
notice has been issued by.
my lord, only thing, my lord, we have not received any demolition.
Take it, give a copy to him. Challenge it.
because that is passed on 4th of August.
Eighth of June.
No.
It's 8th of August, Lordship. 4/8/2025, Lordship. At
8th
the
of
top,
August.
4th August.
4th August.
4th August, self-demolition notice is issued as the.
You have
do
not
have any
received.
sanction plan.
Give a copy.
Right, yes.
All I take down the petitioner in the presented petition is challenging the inaction of the respondent municipality in not taking action against the alleged illegal and unauthorized construction being carried out by the private respondent number 5 and 6 at holding number 306 under Chandanagar municipality. Full stop. It is the case of the petitioner that he is the owner of holding number 304 under Chandanagar municipality. Full stop. He alleges that the private respondent is carrying out illegal and unauthorized construction at the above mentioned property without having any valid sanction plan, and also alleges that the construction is being raised without leaving any mandatory vacant sites, mandatory vacant spaces. Full stop. Petitioner states that he has made several representations. Full stop. Learned counsel for the respondent states that they had conducted an inspection on the above mentioned property and have recorded that the private respondents have carried out illegal and unauthorized construction in the above mentioned property. Full stop. Learned counsel for the respondent further submits that self-demolition notice have already been issued on 4th of August. On 4th of August 2025. Full stop.
Respondent corporation.
Respondent corporation. Respondent jana, respondent corporation. Full stop. Learned counsel for the respondent assures this court that necessary actions will be taken in accordance with law as expeditiously as possible in terms of the demolition order passed by the respondent corporation. Full stop. In view of the said statement, nothing survives in the presented petition. The same is disposed of with the direction to the respondent authority to carry out the demolition action in accordance with law.
No, that, I have instruction that they have not received the notice since the photocopy of the notice.
You should be happy with the photocopy.
I'm not saying that.
Yes.
I'm saying there is a stipulation of 10 days. Since today I have received it.
File a writ petition, sir.
I'm not saying that.
Today you have no right here.
Against me, they have.
That's right. So you have got this, challenge it.
But only I'm saying they have written within 10 days that self-demolition process.
What do you want?
Today I have received this. Today.
What do you want from this court? What do you want from this court? Stay.
No.
What do you want?
Kindly just record what that today I have received the demolition.
A copy of the demolition order has been handed over to the private respondent.
Your Lordship, the affidavit of service.
Affidavit of service taken on record. Fixed और भी है हाँ
This one, then I'm for the petition. एक मिनट बोला थी तापर ठीक तो दे कॉपी तो पाई नहीं
yes
this is fight between the two brothers, joint property unpartitioned, their partition should file. Now, there is a direction interim order is there at page 57. Now, during the pendency of that suit,
I'm for the respondent number
the
six,
private
Lordship, who
respondent
is
being
the
the
brother of the petitioner.
brother, taking signature of mine for the purpose of mutation or something else, made an application before the concerned authority for sanction plan. Obtained the sanction plan without any consent from myself and erected during the pendency of the order passed by the civil court. So I made a representation before the chairman concerned at page 66 that construction is being done and carrying on, subsisting the interim order first, and without taking any consent from myself. So that steps should be taken against the private respondent for making construction. That is the prayer.
No copy of the writ petition has been served to the Purulia.
It has been delivered.
You are the private respondent.
Appearing for the Purulia municipality.
Purulia municipality.
To
Give a
whom?
copy.
I shall. Copy has been served upon the authorities concerned, received also. Again, then I am serving.
I am for the private
So,
respondent.
in the meantime, I paying for staying of construction in terms of the civil court order. Page 57, kindly see. 27/9/2022 itself. On consent and both the plaintiff and defendant number one to maintain the status quo in respect of the nature and character, alteration of the suit property. I believe it includes any nature and character for construction also.
May I submit, Lordship?
Should I refer you
As your Lordship pleases, let them take a
on your representation?
On the representation, because recording my submission that I have not given any consent.
May I submit, Lordship?
Yes, ma'am.
He is not correct. My lord, my learned friend, client, and my client, both of us purchased the suit property, purchased the property jointly in the year 2012. Therefore, thereafter, Lordship, their names have been recorded in the LR record of right before the block land and land enforcement officer, and 2 LR Khotian have been opened in their name. Ultimately, Lordship 17th May 2016, Lordship, upon prayer of the learned friend client and my client, a building plan was sanctioned by the Purulia municipality. This is the building plan. Lordship, his client also signed this plan, and my client also signed this plan. Thereafter, Lordship, I myself and his client, Lordship, prayed for and granting loan before the Bank of Baroda. Bank of Baroda granted loan, and thereafter, I myself, Lordship, constructed the building, one-story residential building. Lordship, thereafter, in the year 2020, Lordship, thereafter, I filed a suit for partition. Lordship, kindly comes at page, Lordship, 66. Lordship, the status quo was there. Maintain both the parties to maintain status quo in respect of the suit property. Lordship, kindly comes at page 57.
Yes.
Page 57, Lordship, in partition suit and interim order of status quo has been passed till the disposal of the suit. Lordship, against that order, Lordship, where his client is the defendant number 1. But the defendant number 1, his client, Lordship, never take any steps for preferring appeal against this order of status quo. It has reached its finality. Lordship, thereafter, in 25th April 2024, he made a complaint that my client made illegal construction and made a complaint to the authority. Already he signed the document and granted loan in favor of my client and his client.
When was the plan sanctioned?
17th May, Lordship, kindly see, 17th May 2016.
And the order of status quo is?
27th September 2022. Lordship, at page 57. Then 25th April 2024, he came and made a complaint before the municipality that I made construction illegally and unauthorized construction. And alleging I obtained the signature of his client, Lordship. But in the sanction building plan, he already made signature, and I myself and his client already obtained loan from the Bank of Baroda. Lordship, that document is lying with me, Lordship. Is it? And not only that, he made a no objection before the Notary Public Government of India affidavit that my client can obtain loan from the financial institution, Lordship, for construction of the building. He has no objection. Everything he knows.
So you go before the municipality, you can put all your documents, everything there. Let the representation be decided by the municipality.
Obliged.
What do you want?
As your Lordship, this is my submission, and I leave it to your Lordship.
No, there are two things which can do. Either you can file your affidavits and all that and continue fighting in the court, or you can go before the municipality in terms of the representation and they can take a decision.
Yes. At the first instance, this can be done.
Lordship, upon hearing, the municipality will decide.
Yes.
And after scrutiny, all the documents. Everything is within his knowledge. And a partition suit is pending.
Your plan was sanctioned in 2016.
Subject to correction, she is not probably addressed properly. This is sanction plan, alleged sanction plan in the year 2016, valid for 3 years. But in terms of the Act 2011, valid on completion of building must be done within the period of 3 years. That means 2019. He did not do this. Now, after the status quo order in his suit, he is to maintain, he is violating, making construction after the injunction.
What is the illegality as far as the municipality is concerned?
Because of the fact the sanction plans now beyond the allegedly, even assuming this is the valid sanction plan, assuming it is to be completed within the period of 3 years from the date of giving sanction in terms of the section 211. But it is kindly, if your lordship kindly sees this rules itself, it is to be completed.
Yes.
No construction done. Therefore, validity of the therefore, validity of the construction to be completed must be done within the period of 3 years. It was not done. Now, in the year 2022, in his suit, status quo order was passed. That he cannot violate the status quo order as on the date of construction is being made after that. That it is to be decided by the municipality first, because at the outstage I have submitted that it is to be decided by the municipality first. Then your lordship make a judicial review if any illegality passed in either of the side.
My lord, one-story building has
the
already
law of the
completed. I am residing there.
All right.
I am residing there.
Be decided first.
Take down.
I oblige to your lordship, my lord.
Let them file their report. Nothing doing. The petitioner in the presented petition is challenging the inaction of the respondent municipality in not taking any steps for stopping / demolishing the unauthorized construction made unauthorized construction being carried out at the land situated in municipal holding number 1968/1167/2 Surya Sen Pali Mohalla, RS Khetan number 213, RS plot number 3836, Mauza Raghapur, PO and PS Purulia Town, Ward number 3, Purulia Municipality, at the instance of respondent number
6, I believe.
6.
Yes.
At the instance of respondent number 6. Learned counsel for the petitioner submits that the petitioner, the respondent number 6, the petitioner and the respondent number 6 are co-owners of the aforementioned property, which stands duly mutated in their joint names in the municipal records. Full stop. Learned counsel for the petitioner submits that the private respondent number 6 fraudulently obtained petitioner's signature on certain documents, and on the strength of the same got the building plan sanctioned from the respondent municipality. Learned counsel for the petitioner submits that petitioner, the respondent number 6 instituted a partition suit being titled suit number 266 of 2020 before the learned civil judge, senior division, Purulia. Full stop. He further states that by order dated 27/9/2022, the learned civil judge was pleased to direct the parties to maintain status quo with respect to the nature, character, and alienation of the said alienation of the suit property until the final disposal of the suit. Full stop. He states that in blatant violation of the said order, the private respondent had carried on with the construction in violation of the order. Full stop. Learned counsel for the private respondent number 6 submits that the petitioner, along with the private respondent, had taken loan from Bank of Baroda for construction of the said construction on the said property. Full stop. She further states that the building plan was sanctioned way back on 17/5/2016, and that the order passed by the passed by the civil court in the title suit is much later in time, i.e. 27/9/2022. Full stop. She states that respondent number 6 had not carried out any illegal or unauthorized construction on the said property, and that they had a valid sanction plan, and the entire construction is raised in terms of the sanction plan, in terms of the valid sanction plan. Full stop. She further states that the petitioner and respondent number 6 had jointly applied for the sanction plan before the Purulia municipality. Full stop. It is on the basis of the joint inspection that the sanction plan was that the building plan was sanctioned on 17/5/2016. Full stop. She denies all the averments and contentions made by the learned counsel for the petitioner. Full stop. She seeks and is granted 4 weeks time to file her affidavit in opposition. Full stop. Affidavit in opposition, reply to the same, if any, within 2 weeks thereafter. Full stop. Learned counsel for the respondent corporation states that the entire municipality states that the entire construction has come up based on the has been constructed. The entire construction has come up on the basis of a valid sanction plan issued by the municipality. Full stop. He further seeks and is granted 4 weeks time to file his affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter. List after 10 weeks.
One small prayer.
Nothing.
Lordship, one thing remains, Lordship, his client already started construction
Sorry?
before the vacant portion.
You challenge it, madam. That's your lookout. That issue is not here.
এই দে না প্ল্যানটা দে
ये दो
Next করে দেবে?
19th November.
প্ল্যানটা দে
Annex করে দেবে তো?
দেবো তো নিশ্চয়ই দে না
19th November.
Obliged to your lordship. No interim protection in the meantime.
No interim protection.
All right.
interim protection already
Not protection.
Not
Brothers
to
fighting,
construct further.
nothing else.
All right, my lord. I
I'm grateful, Lordship.
obliged to your lordship, my lord. Get
19th November.
a bit of service today. I have.
Affidavit of service taken.
Which is
I'm grateful, Lordship.
obliged.
Affidavit of service.
এইটাই
Keep it on record.
তোর কাছে রাখছিস কেন? I'm handling.
সরি স্যার না আমি এটা দেখছিলাম সামনে ছিল
I'll be
I'm appealing for the Kolkata Municipal Corporation.
This case, my lord, I appear for the writ petition. Well, I am filing the affidavit service. The instant case, my lord, relates to mutation in respect of premises number 16A Hajar Road. And my client, my lord, made the application for mutation because he got the property by way of demolition. Now the application which was, my lord, filed before the authorities concerned, they took up the matter for consideration. But after the consideration of the matter, once, my lord, they did not pass any order. We are waiting for the communication of the order. Then, my lord, I moved the writ application before this court. Illogically, see, I just place your lordship with some of the from the stage of the order passed by the honorable court.
Page 21.
At page, my lord,
21.
21, order dated 17 December 2024. Hearing was done, my lord, on September 11, 2024. Since it was not, my lord, nothing was communicated. We approached this honorable court. The court directed to communicate or, my lord, the passes an order. Then the order was passed, my lord, which is at page
24.
24. Illogically sees that the acceptance of the issue of the recording of the name, just I'm reading my first three, 4 lines. The property in question in premise number 16 Hajra Road is recorded in the name of Sri Shoshi Bakumar Banerjee. Once Sri Shantanu Mukherjee applied for the assessment register copy of the against the caption premises by submitting the copy of the will and the probate registered boundary declaration dated 5th July 2024 and self-assessment form duly signed by Shantanu Mukherjee, Sandip Mukherjee and Prithvish Mukherjee. On 23rd July 2024, the concerned division has initiated proposal for recording of the land area followed by the assessment of annual value of the on the basis of the submitted registered boundary declaration before the TRS district sub-register 4 South 24 dated deed number dated 5th July 2024, stating the land area 8 kathas 2 chitax. The competent authority approved this file on 23rd July 2024 with an annual valuation of rupees with effect from 4th quarter 2016-17 and 1st quarter 2017-18. Therefore, the formal approval that was recorded that the file was approved and the valuation was assessed. And that valuation, they according to them, that the declaration of the area of the land which was mentioned, my lord, 8 kathas 2 chitax. On that basis, they my lord calculated the amount of annual valuation.
Property quarter.
Then you logically come to the next page, the ordering portion. Ordering portion logically kindly come to
Therefore.
the last part. Therefore, Mr. Shantanu Mukherjee is directed to submit additional necessary documents in support of his, my lord, got it, my lord? Additional support of a claim of his registered instrument with respect to premises in question to verify the land record and make physical boundary of his property for verification in the field. Completion of pending assessment, especially under the unit area assessment system, recording correct land area is a prerequisite for mutation. Issue of mutation shall be considered thereafter upon getting the formal application from the concerned parties in pasted A42 form and relevant documents to be attached with duly filled up form for which none of the parties have submitted yet. But first of all, my lord, the application is required to be made in a plain paper, but they say about the A42, although it's not a prescribed form under the act and the regulations, but they administratively they have prepared the form. However, my lord, in that form had also been submitted by us. Illogically, see, my lord, the next page, P3.
The enclosures, A42 form has all the required documents have given.
Illogically, see, my lord, the next page.
Yes.
The documents were enclosed. I forward the letter in terms of their requirement that the documents were A42 form, self-assessment form, copy of the registered deed of declaration of the ownership, current NOC, affidavit of payment of pro rata share of tax.
Yes.
These are the documents that have been submitted. Now, my lord, they have come
Page 51.
to page 51 after receiving all this, my lord.
They acknowledge that they have received
They
it.
acknowledge, my lord, everything, and they come at page, my lord, 51. You can see, my lord, this is really, my lord, we are questioning because, my lord, they have not, my lord, when you was said rejected, but it's amount to tantamount to, my lord, the refusal to grant the mutation.
Last line doesn't exist.
Theoretically, can we come to the last page, the existence of so many registered boundary declaration, differing one from the other, there is a serious question about the reliability of the veracity of the instrument. As such, you are requested to submit a registered deed in respect of the present question at the earliest for completion of the pending assessment. But I am submitting, well, that this registered deed, what registered deed asking, because I do not know, because well, they can ask the registered deed, say demolished, the property has been devolved upon my client. And well, under the act itself, we will also see this section 183, the in case of devolution, it is to be intimated to them. There is the question of well, registered deed.
No, but what was the need for sometimes saying that the property is 8 katta, 2
No,
chattaks,
that
sometimes 10 chattaks, sometimes 3 chattaks?
I admit, well, that I've seen. Well, that, well, the two, well, the boundary declaration, because it is done by the person who is measuring the property.
No, but you only submitted the document, the
No, I
first,
submitted, of course, well, it is my declaration.
the first boundary
But
declaration.
finally, well, what I submit, that tallies with what I initially submitted to the district sub-registry officer. That tallies, my lord. The last one which I submitted, that, my lord, you logically see, my lord.
Next page 52.
Page 52, my lord, it tallies the last boundary declaration.
আমি সবকিছু আবার দিয়ে দিলাম, দিয়ে ওকে বলে দিলাম this is my final, full and final.
Well, I said, my lord, in the last occasion that this is the final, my lord, my document. And that, in fact, my lord, a variation, I, of course, my lord, I find, my lord, that the variation, my lord, a little, my lord, the chitaks, only that variation, not the major valuation of the land area. Boundary declaration requirement generally, boundary declaration is required for identification location of the property.
Yes.
But area is calculated at the time of assessment. If if my calculation of the area is wrong, the authorities can, my lord, obviously, my lord, measure it and look into it, and the whatever the valuations to be made, they could do it. There is no difficulty. But they must say that registered deed, that is not a requirement under the act itself in case of a devolution of the property to the successor of the property. But they accepted, approved. Now they say, my lord, that district sub-register, what they calculate the property, the first document, my lord, which I submitted before the district sub-register, that also the same area of land, 8 katta, 3 chitaks, 14 square feet, and last one also when I said 8 katta, 3 chitaks, 14 square feet.
The first one
And
was,
in between two, my lord, there is a little variation in respect of chitaks. That I said that this is my final document, and that tallies with the first one, which is the submitted before the district sub-register officer.
Registered declaration I have given. Last one. No, correct.
Therefore, I said, well, this is my final document. But I submit to your lordship when the assessment of the property, that the calculation to be made, I understand the unit area assessment. Yes, my lord, the area is, my lord, mentioned. Like if the area is found to be, my lord, wrong to some extent, because the
sir, unit area method, you have self-declaration form.
yes, a self-declaration, but now finally when they have asked me by their order, their, my lord, I corrected everything after the last order of the authority. Now they are falling upon that registered deed, but which I am submitting, but that is not required under the act itself. You know, you can see section 183.
SAP form আমি দিয়েছি স্যার।
And SAP form also submitted, but reference.
Page 26.
KMC একটা ছোট
SAP form
Which section? I'll just.
183, man.
Of Calcutta?
Calcutta Municipal.
ওই জানিস না কেন
Really got it, madam?
Yes,
Section
sir.
183.
Just. Yes.
The guy is 183.
Yes.
Whenever title of any parcel to any land or building is transferred, such person is primarily liable for the payment of property tax on such land or building, and the person to whom the title is so transferred shall within 3 months after the execution of the instrument of the transfer or after its registration, if it is registered, or after the transfer is effected, if no instrument is executed, give notice of such transfer in writing to the Municipal Commissioner. In the event of death of any person primarily liable as aforesaid, the person on whom the title of such land or building devolved shall within 6 months from the date of death of the former give notice of such devolution in writing to the Municipal Commissioner. Therefore, no deed is required because it is the property already lying recorded in the assessment register of the corporation. The petitions are already on record. Therefore, my name to be mutated because of the devolution. The will and the probate, everything is with them. They are submitted, and on that basis, they approve the file. Thereafter, they say, these are the documents needed. I submitted now every document. And after that, they are not doing anything.
Yes.
May I make my submission? It is admitted fact that there are veracity in the area of the deed of declaration. On 2 occasions, they have given 2 boundary declarations. That is why in the order itself, it has been mentioned additional necessary documents just to see what is the exact correct area.
Yes.
My learned senior friend has shown section 183 for mutation. It is simple mutation, but for the self-assessment, if the assessee failed to make self-assessment, the municipal commissioner can suo motu make the self-assessment. In that event, he has to put the correct area. Since during the hearing, it has cropped that there are 2 different areas given by themselves. And in this particular case, the first page of the order records there was objections. And objections by whom? The person whom they have given power of attorney on the earlier occasion. So the question arises, what is the correct area? And when any objection has been given, it cannot be taken as a simple A42 mutation. And I do not find any illegality in the order. Letter issued on 11 March 2025, whereby only a copy of the registered deed has been asked for. What is the difficulty in producing the registered deed? It has not
don't
been
have a
denied.
registered deed?
It has not been denied.
May I submit one thing, my lord? Let there be direction. That
Are you?
client has, my lord, we are the private respondents in earlier petition made by my learned senior friend. And my lord, on the earlier petition, there was specific direction also to consider my contest also, my objection also. But I don't know what is the reason in this petition they have not made a party to me.
Why did you make them a party? They are the objectors.
And there is lots of suppression of facts. And one origin.
Why they are not party? First, make them a party.
Contesting probate is pending.
Make them a party, Mr.
Contesting
Ghosh.
probate is pending, my lord.
Wait a minute.
Yes.
Make them a party, Mr. Ghosh. Make them a party.
Let there be direction to serve a copy upon me.
Learned counsel for the petitioner seeks to add the private respondents, the objectors, before the objectors before the municipality. You are also owner.
My lord,
No, he takes for certain documents.
my lord, one probate application is pending.
Private respondent number, private
Earlier
respondent. So
application- earlier application, we are 6 to 10, lordship. Private respondent number.
make them a party, Mr. Ghosh. Learned counsel the petitioner seeks and is granted 1 week.
Yes. Well, I will incorporate their names, my lord, in the fellowship class may leave in the petition itself. After the lordship leave.
And a
And I
copy
will
be
serve
given.
I will serve a
be
copy to him.
seeks and is granted liberty to add the private respondents as party to the present writ petition. Necessary steps shall be taken. Let this matter be listed after. We'll keep it after 1 week.
Well, 13 and 14, I have some difficulties. It may be on the 18th or 19th, as per the convenience of your question.
We'll have it on 26th August.
I'm grateful.
I'm grateful, my lord.
Affidavit service. उनका तो रख लो. Affidavit service taken on record.
Address is same, everything same.
I am appearing on behalf of the state.
I'm appearing for the respondent number 5 to 7, Your Lordship.
6, 7, 8.
I'm for the petition, Your Lordship.
I've been directed by you, my lord, for filing a report in the form of affidavit.
What is it?
The copy to
Lordship, on earlier occasion, they had filed one affidavit.
What is this?
There were mistakes
Any
and
direction?
corrected.
Yes, the direction was given to us.
You're appearing for Bhatpara?
What?
Lordship, they have annexed various documents, Lordship. The municipality and the state are fighting, Lordship, and I am dying out of starvation. I am not getting my pension
My lord, so
from
far the
April,
rule is
Lordship.
concerned, my lord, municipalities should pay from their own coffer, my lord. Rule 31 says, my lord, kindly see the rules I have already submitted before the coordinate bench, and coordinate bench at the time of passing the first order, my lord, has recorded it. My lord, kindly see the rules. DCRB rules.
Have you filed your report?
No, there is no question of the report has been filed by the municipality, my lord.
Yes.
My lord, rule says, my lord, so for the DCRB rule says, rule 31, my lord, so for the pensionary benefit is concerned.
Sir, we all know that you have to make a contribution to the pension. That is not an unknown fact to anybody, that you have to pay your contribution.
Yes, but rule says, my lord, kindly see the rules. The pension rules under this rule shall be paid by the municipality from its own fund. My lord, kindly see the rules. For a moment, your lordship, kindly see the rules.
You also file your report in 2 weeks. Bring all the rules and everything on record.
Lordship, some pension may be released, Lordship. From
Not right now.
I am not getting, Lordship.
Let them file their.
Lordship, at least 2 months.
I can't give any pension, madam. Interim orders can't be passed like this for pension.
Lordship,
Are you giving them any?
They don't have any fund in their affidavit, Lordship. The documents they have annexed.
Any provisional pension is being paid to her?
No, Lordship.
In March, we have cleared all pension.
Till March.
March 2025.
Yes.
Lordship, what we are facing is, we are not being able to pay in time. So when we come to the court, sometime interest is imposed upon us. Now, Lordship, there's a huge failure in the machinery. Lordship, there are two sources of my fund, my own generated revenue and the state assistance. Lordship, since the state assistance, if your Lordship kindly see, I've written that 4.644, I received in 3/12/2024, but no fund was even received after the lapse of 3 months from our submission. Page 3, if your Lordship, I have given that every detail of it. On the last day, when the Lordship, there was a 2-issue list, that what are the funds I have received. 40%.
Heard, CAV. Will pass an order.
Lordship, what I was saying only.
Yes.
If your Lordship kindly allow me another day's time. Lordship, I will explain from the constitutional provisions, and there are one judgment in the passed by the Honorable Division Bench of this court, that is particular to commercial matter. What happened whenever there is a
Learned counsel for the parties are directed to file their written submission within a period of 3 weeks, along with all the relevant judgments they wish to rely upon.
If your Lordship kindly
CAV.
15 minutes instead of CAV, if your Lordship allow me 15 minutes time, Lordship, I will show the constitutional provision and 2 judgment, whereby I will show how the state government is being liable, because from the municipal law I will show all the property belong to me. I cannot even sell. The property belongs to me, but for every sale and to deal with the property, I have to take a prior permission of the UD department, Urban Development Department. Now, Lordship, if your Lordship sees the fabric of the municipal act, then Lordship will understand that I am a local body, but completely under supervision and financial control of. So I am not an independent statutory body. It's not a municipal act guided me. Apart from the municipal act guides me, the fiscal budget of the state has a resemblance on me. So that's the reason why I receive fund from the state government. I have written Lordship. Now, if there is any delay in receiving the fund, which is happening very often, previously it was not. Lordship, in that case, Lordship I will give it data before your Lordship. So, regard to other municipality, I don't know about municipality.
It's not a public interest litigation, sir. We are only concerned about this particular employee.
So, Lordship, but I will try to show in my district, at least in my district, how the municipalities are being suffered.
Good, we'll wind up the municipality.
That is Lordship's hand. That is the desire of the state government to keep it as a municipality, or they can.
The appointing authority?
Yes. Like Newtown in Calcutta, that is not under any municipality. It's a notified area.
I'll file my respective.
So whether he will keep me in a notified area or he will keep me in a municipal area, that's completely decision of my state government. And of course, I am in the hand of Lordship. But what I am trying to show is, if I do not say this today, tomorrow if your Lordship directs me to make any payment and I am unable to make payment, then I am personally liable for the contempt. And then I have to, in the contempt matter, I have to go and justify that is not my deliberate fault. This is non-availability of the.
You have already said that you can't make the payment because you don't have the fund.
Lordship. So if your Lordship.
So we'll auction your properties, we'll recover the money from there.
Lordship, I have disclosed my balance sheet. I have disclosed my deficit fiscal budget. Lordship, I have.
You have properties also.
Yes. Yes, but that's exactly what I'm saying. I cannot deal with my property. All property belongs to. That's why I said, allow me 15 minutes time. I will place two judgments and
you argue it now. We'll hear you.
That judgments I am not ready.
Why?
With. Judgment I was not ready with. I thought that they might.
You have come here to argue the matter.
I should have come. I should have come. If your Lordship kindly keep it any day, tomorrow, subject to Lordship's convenience for 15 minutes. By what?
The Lordship has already directed to file.
You have come with the judgments.
We'll file.
It is listed for hearing.
No, I'm sorry, Lordship. I should have. If your Lordship kindly gives me another 10 minutes time, tomorrow, day after tomorrow, convenient to you.
I'm ready to give you half an hour time.
Today, Lordship, I've not been able to arrange those. Your Lordship, allow me one day. In this report, I will file that and mean.
Just taking these.
They'll file their respective notes, no problem.
That's all right. But if your Lordship allow me 10 minutes.
So I'm giving you time, then you file your report. Learned Counsel for the state is directed to file its report. Seeks and is granted 2 weeks time to file its report by way of an affidavit. List on 2nd September.
2nd September.
Lordship, I will file exception on that date.
Exception, if any, within a period of 1 week thereafter. List on 2nd September.
I'm
Grateful, Lordship.
My Lord, I am appearing
for the state of West Bengal, Lordship.
My Lord, I am appearing for the petitioner. My Lord,
Yes.
petitioner main grievance is the budget for the year of my Lord 2025. It was not approved by the councillors. That's why, my Lord, and subsequently, the my Lord chairman was my Lord paying the money, entire money without budget. So there is a total violation of.
Mr. Mandal, they have filed their report or not?
Lordship, may I file my report?
My Lord,
Lordship
can
is
you go through
directed to
that
file a.
page para. Okay.
I'm filing a report on behalf of
Para 6 and
director
para
of
9.
local bodies.
What is this? All your volumes?
No, this is the opposition. It is, my Lord, is totally audit report. This is
Lordship,
not the
in
demand.
respect of respondent number
Demand
4,
is
they have
that
stated that they do not
budget
have
was
to
not
say something.
approved
I've
by the
received this instruction yesterday itself, so I could not put it on affidavit. May I file this? My Lord directs, I can put it in form of an affidavit. May I rely on a document submitted along with the report at page 8 of my report?
Yes.
We have written to the chairman to intimate us regarding the budget approved by the Board of Councillors. And if it is not approved, a justified reasons with details. They have not sent us anything, therefore we have referred this matter to UDMA, Lordship.
Yes.
We have not heard anything from UDMA till now, but UDMA can take steps under section 431 of West Bengal Municipal Act.
There are 5, 6, and a 9.
Yes, Mr. Vandal.
My lord, total violation of Municipal Act. My lord, without budget, my lord, they disburse the money.
Yes.
That's why I praying for my lord inquiry from the higher my lord authority to inspect against the my lord chairman, so that there is a total disburse of money without my lord budget. There is a huge scam by the my lord chairman, the then chairman. My lord, that's why I my lord prayed for inquiry to the SP or my lord ACB. My lord, it's a totally prevents my lord anti-corruption.
My lord.
My lord, PC Act maybe my lord use preliminary inquiry so far my lord against the chairman is concerned. Without
My lord.
budget, my lord, any amount could not be my lord disbursed by the not even 1 rupees. My lord, kindly go through the para section 82 3 first my lord, there is no budget, and so far my lord disburse of fund my lord 69 section 69 2 and 3.
West Bengal.
West Bengal Municipal Act.
My lord.
Yes, what are you saying,
my lord?
Mr.
My
Samanth?
lord. My lord, I am appearing for the municipality, my lord. Last occasion, I have already intimated your lordship that no confidence motion has been moved on 28th. They have some councillors have conducted the meeting and they have removed the chairman, purportedly removed the chairman, my lord.
Another
My lord.
issue. It is
My
another.
lord, the next day, my lord, the government already had intervened. They have so-caused the entire board regarding all the irregularities, and they have so-called under 431, my lord, and they have given 7 days. The 7 days end today, my lord. And yesterday, my lord, the new vice chairman who has taken the charge of a chairman, they also removed us. So, my lord, that all we can inform the court, my lord. That is all my submission is there. The new vice chairman yesterday removed us. At night, they send a mail.
Is admitted fact.
You are appearing for the municipality.
There is a corruption.
Who appears for the municipality? You are appearing. Have you?
My lord, at last time I was appearing, my lord, because yesterday night they sent a mail that your year is not required.
Because you has been removed from the post.
My
My lord,
service is not
so far,
required,
my
they
lord,
sent a mail.
Yes.
my lord, kindly go through first, my lord, section 82, subsection 3. My grievance is there is no budget pass approval by the councillors. My lord, if my lord budget pass, the copy of the budget, my lord, section 82, subsection. A copy of the budget instituted adopted by the Board of Council shall be sent to the DLB for the information and shall be available inspection by the member of the public of the manner. My lord, that budget, my lord, earlier, my lord, chairman submit before your lordship, kindly see the first order passed by your lordship. What, my lord, they submit. They have submitted. First order. My lord, kindly go through the order dated 21st May 2025, para 3. Para 2, page 2, para 3. Landed council for the respondent number 5 to 10 dispute the aforesaid consensus that the submit that councillors were indeed present at the meeting held on 7th 2025 and are duly approved by the said resolution. My lord, that budget is approved, that should be sent to the, my lord, UDM, my lord, direct DLP.
Local
My lord,
bodies
that
are
was not
bodies.
sent, it was revealed from the affidavit placed before your lords. Para 5, 6 and para 9. It was revealed that my lord was not sent. Though, my lord, after budget pass, the should be, my lord, copy of the said budget should be sent to the DLP. It was not sent. And so far revised budget is concerned, that should be, my lord, specific time frame in, my lord, 82 subsection 4 should be within October that year. That was not done. Thereafter, my lord, kindly go through, my lord, disburse, so far disburse of fund, section 69, subsection 2 and 3.
I've taken all this in my report.
Yes. That was not, that's why, my lord, there is a huge scam. My lord, kindly direct an inquiry by the ACB or, my lord, any other, my lord, agency. Preliminary inquiry may be conducted by the, my lord, authority.
Now, what does the law provide, Mr. Bundle? If there is any discrepancy or any illegality.
FIR should be lodged against the chairman.
No, that is first who will decipher
First,
whether
preliminary inquiry should be conducted.
under the law who has the power. The DLB has the power. Who has the power?
My lord, separate. My lord, DLB could file a first information report, and there is a first inquiry. And inquiry for
DLB.
there is a corruption. My lord, there is a.
You are appearing for the DLB.
Yes.
What is your inquiry?
Lordship, we have asked for the report, Lordship, since
Yes.
it's not given us anything. We have referred this matter to UDMA, which is the appropriate authority for this.
Under the law.
Yes, UDMA. UDMA
DLB
is
is a
the
Show me the section.
director of body.
power of state government to intervene in cases of gross negligence or gross irregularity. May I place the section?
Board of Councillor petitioner before your lordship. My lord, kindly send to the vigilance and kindly call for a report from the vigilance.
No, no.
Any, my lord, irregularities happened, sir.
Mr. Mandal, that will only be done. See, we are not here for the press. We are here to solve the issue. If there is a local inquiry which has to be conducted or internal inquiry has to be conducted, let us go step by step.
Yes.
If it has to be sent to the vigilance, we will send it. But we will not jump the gun.
That's your point.
So I need your assistance,
Yes,
Mr. Mandal, to that extent that before we take that action, we should exhaust all the remedies which are available.
Yes.
I pass an order, I send it to vigilance, they go, they challenge it, they get a stay.
Your lordship.
Let us proceed in accordance with law. So you please guide me and please show me the relevant provision where if there is any
Irregularities happen.
Yes.
What?
Yes.
In accordance. Hey, আমি কি দুদিন সময় নেব? দুদিন সময় নেব? হ্যাঁ?
We can have it next week also, Mr. Mandu.
Yes, ma'am.
We'll have it next week. Be prepared.
Yes, yes.
Before we jump the gun
Yes, ma'am.
and straight away direct the ACB or anybody, let us go step by step.
Let us go step by
I
Step
will
by
also take instruction who will be the appropriate authority because section 427, 428, these are the sections stating inspection of the municipal works and all.
Yes, you please
Lordship.
get instruction.
Lordship.
So we'll have it.
Thank you.
When do you want it, Mr. Mandu?
Next week, then.
UDMA the instruction.
Next would 6th,
I have filed the report.
13th. 13th, Colonel? Mr. Mandal, 13th August? 13th August. Please take instruction
It
also.
be recorded, I have filed a report.
13th. Report,
Next week.
On behalf of respondent number 2,
report is neither here nor there.
stated everything that I have forwarded it to.
Yes, but then that doesn't help. That doesn't help.
There was a direction of my lordship to file a
Report,
report.
report filed by the, by respondent number 2 is taken on record. Let this matter be listed.
Your lordship's fixed on 12, there is.
12? All right, 12th. 12th.
Grateful, my lord.
Is lordship rising?
Not yet.
Not. Then I'm waiting because I have to mention a matter.
For the municipality lordship, let them.
In terms of your lordship direction, my lord, yes, my lord, I am for the petition. My lord, in terms of your lordship direction, my lord, I have served twice, my lord, on the Raghunath Chatterjee, my lord, twice, my lord. But they have not turned up.
I am for the municipality lordship, led by Mr. Raghunath Chakraborty.
Oh, please, my lord, she is representing.
I saw Ms. Sen Gupta yesterday also, I was looking for her. Ms. Sen, yes.
My lord,
Yes.
in this matter, my lord,
Have you received the brief, Ms. Sen?
Yes, lordship.
You have it? What are your instructions?
Lordship, let me come back with the instruction why they have rejected the application. They have,
We'll have it next week.
yes, lordship.
Get the instruction. Next week. At least they have appeared. At the request of the parties, let this matter be listed on.
my lord, I have represented first time. After 3 days, they have refused. After 1 year, I have represented first time. That kindly grant me the sanction. After taking that representation, within 10 days, that has been rejected without any rhyme and reason. And now we have submitted even district judge's order, all the documents, portias, khajanas, all the up-to-date documents, titled it, everything.
You
But
decided
in spite of
representation.
that, my lord, they have rejected without any rhyme and reason.
It has rejected the application lordship, so I
He
have
has
to
made a
why put this-
representation after the rejection of the application.
Well, kindly have a look, page 34, my lord. Kindly have a look once, my lord.
This
Page
direction
34.
lordship will according to.
You'll consider the representation.
Last representation, my lord. And my lord, kindly direct them to file a report before your lordship, so as to my lord, matter can
Either
be.
it is
Municipal has
representation
rejected.
or it is report. What do you want?
My lord, first thing, my lord,
Municipal
if
has rejected lordship,
What do you
their
want?
application
So let
status.
you seek instruction. We'll have it on. Let them come with the instruction.
as your lordship, my lord.
Lordship.
We'll have it on 25th August. 25th August. At the request of the parties, let this matter be listed on 25th August. ये किसका है? हाँ, okay.
এই ফিল্ম সেটটা দিয়ে দাও আছে দেখো হ্যালো এভিটিভ সার্ভিস kept on record let my affidavit service be kept with the record affidavit service
Give it on that day.
oh my as your lordship and
लिख लो affidavit of service is taken on record. Learned counsel for the respondent seeks and is granted time to take instruction. Let this matter be listed on 25th of August.
Beautiful lordship.
Give it back to me.
may I take with this later
Letter you give it to her. That's her letter.
I've seen it
अच्छा.
with the copy below ঠিক আছে চলো great lordship much
My lord, I am appearing for the petitioners, my lord.
Respondent Viceroy, Content Municipality.
Affidavit of service.
One die.
My lord, may I proceed?
Arrears of pension.
My lord. Matter is relating to retired deceased municipal employees, family, area pension and gratuity, my lord.
Yes, why you're not releasing it?
My lord, arrear pension has already been paid. This is a verbal instruction we have obtained. The arrear pension has already been paid, but this is an admitted fact that 2,80,000 gratuity is still due.
No, my lord, kindly I have to submit. My lord, kindly come to the petitioner's husband already expired on my lord 12/8/12/2020. After the death of the petitioner's my lord's husband, the authority concerned settled the pension 12,500. The municipal authority also, my lord, kindly come to the page annexer P4. Municipal authority concerned also handed over an order where the details of the pension
Page
annexer P4, my lord. Annexer P4.
The page number, tell me the
Yes,
page
my
number.
lord, page 70.
17.
Yes.
And the VPO portion, my lord, page annexer page 16, P3. My lord, the full gratuity amount depicted in the PPO portion, my lord, 7,30,000. The authority paid the 4 lakhs only on different consecutive dates. Now, principal due amount of gratuity, my lord, 3,30,000, not yet been paid till today. My lord, as per law, the gratuity amount will have to pay within 30 days after the retirement. Now, coming to the no pension given by the authority concerned from 9/12/2020 to 28/2/2021. My lord, only ad hoc pension given by the authority rupees 6,075 from 1st March 2021 to 13/11/2021. My lord, thereby total principal area of pension amount 1,02,096.
Right, we'll have this after lunch. Yes.
Which calculated
after lunch. Yes.
I'm constrained to mention a matter where Lordship ordered it out. While go up.
Lordship, on 28/7/2025, passed an order. None appears for the state. Even on the last occasion, such and such date, there was no appearance on behalf of the state. Mr. Devjit Mukherjee, who generally appears for the state, is present in the court. This court requests the Devjit Mukherjee
Yes.
assist the court in the present of the decision.
Yes.
In this writ petition, state is not the party. Thereafter, Lordship directed to regularize the appointment of the Devjit Mukherjee.
Yes. State
So
is
the
not a
state-
party.
No, this is the writ petition, Lordship. If Lordship can leave to state as a party respondent, I can regularize their appointment.
The officer in charge,
Officer in charge.
Eco Police Station,
Yes. That has not been served.
they have not been served.
They never served any copy to the learned government pleader office.
Why are you so agitated? Is there a problem?
Problem is not there. They come to regularize his appointment. But the
All
state,
right.
but the state is not the party respondent.
All right, we
If
heard.
I regularize that appointment,
Yeah.
they will not get the bill.
That's all right. You can move an application. We will amend the order. What is the big deal?
No. This is the problem, Lordship. Each and every day, one after another advocate will come, regularize the appointment. They never see that state is the party respondent or not. They can request the Lordship, the state kindly can leave to party the respondent of the state.
The lawyer has not done it. That doesn't mean we will punish the lawyer. All right. They are all part of your fraternity only. He has not come from somewhere else.
Then the petitioner will
When is this matter listed? एक बार इसको देख लो. Mentioning पे इसको लगा दो. Keep it on mentioning on Friday.
Mention on Friday.
To be mentioned. To be mentioned, we'll have it on Friday.
Lordship.
And they are all your part of the team. Why are you getting agitated about their appointments? He should have pointed out.
Wait for your lordship.
Yes,
My lord, may I be permitted to proceed?
yes, sir.
My lord, kindly come to the read petition, page 4, where all calculation will be given in a para F and G regarding the gratuity calculation.
Para E.
Para F and G, page 4.
Yes.
And page 5 continue.
Yes.
And regarding the area pension, my lord, already given J, K, and I regarding the area due pension, my lord.
Yes.
And after, my lord, I have taken the instruction from my client now. After filing these writ petitions, 50,000 paid by the concerned authority concerned to my client. So not more than that. The calculate the amount already, the account already given, the passbook annexed here, my lord, in page from page 18 onwards.
Yes.
Page 18 to page 35, 36 one.
Yes.
So the due amount, which calculated in my prayer also, in my prayer kindly page 11 of the writ petition, the para 10A, para 10A. 1,02,096 due arrear pension and 3,30,000 due gratuity amount. And now only 50,000 will be deducted from here.
Already from the death of the disease, the arrear pension has been calculated. On that occasion, as an ad hoc pension, they had paid 60,750 rupees. That has been credited on their account. Thereafter, my lord, thereafter, in the year 2023, again, I'll hand over this slip. 96,000 to 20 rupees has been credited. The whole amount arrear. This has been paid in the year 2023. The whole amount of arrear pension has been cleared from our side. There is no other due. And on basis of their calculation, it seems to be from the writ petition, it is 1,02,000 rupees. But from our calculation, it came to be 1,57,000 rupees. From that 1,57,770 rupees. From that, the ad hoc pension which has already been paid has been deducted. Thereafter, the deduction, the amount coming is 96,020 rupees, and the same has been paid, and that is the reading. Now amounting to the gratuity amount that we are admitting the fact that as per their claim petition, this 3,30,000 rupees. Among that
30,000.
30,000, 50,000 has already been paid to their account in the year 2025. Thereafter, the remaining 2,80,000 may kindly a direction on an installment, we will pay the same. Due to the lack of fund or insufficient fund, currently we cannot proceed. So within the stipulated time given by the court, we will proceed this whole amount.
My lord, the amount already
He dispute that. The problem is you have to file it on report by way of an affidavit so that he can file his exception, because he is going to dispute it.
it will take time, my lord. The petitioner is ailing.
If you admit, sir, I can dispose it off. If you admit that the entire arrears or the statement made by her
no,
is,
no, I had.
I said it before, you will say it. Unfortunately, we were also that side. Na?
As your lordship see here.
So looking at lawyers, we can understand.
Next week. The next 1 week, going to the contact again, taking the report.
For 2 weeks at least.
3 weeks.
3 weeks. The petitioner, if you admit, we can dispose it off. Will you admit?
From the date after.
Because
You admit that the
I have-
entire arrear, what she's saying, has been paid and 50,000 has been paid. So the balance is only 2,80,000. I'll give a direction. They will release the money.
The bank account statement already annexed here, my lord. Apart from that, I can't say.
After that, payments have been made. But a lot of time, the clients don't tell you the exact payment. Like just now you got an instruction.
Just after the death from the ninth, the client has died on the 8th. From the 9th, we have started the calculation.
And sir, you have annexed entire bank account. I'm 100% sure you would have not seen each and every page and every entry of the bank account.
My lord, maybe.
Neither you nor your client.
My lord.
They will not make a statement that they have made the entire payment of arrears without any basis.
Look.
What? What do you want?
I will file a affidavit.
The petitioner has preferred the present writ petition, being aggrieved by the inaction of the respondent, authority not releasing his arrears of pension, and this is death gratuity. Arrears of pension and gratuity amount of the petitioner's deceased father, despite a lapse of 5 years since his death. Petitioner's husband, you are the son or you are the wife or the son? What are you? Petitioner is what?
I'm the wife of the
petitioner's
employee.
deceased husband.
I'm the wife of the deceased.
Not son, deceased husband. Petitioner's husband was an employee of the respondent municipality. Respondent municipality, full stop. He expired on 8/12/2020. 2020 you died, right?
Yes.
8/12/2020.
The petitioner husband retired on 8/12/2020 and on the same date expired.
Same day?
Same day. Expired on same day.
He expired on 8/12/2020. Full stop. After his death, the respondent municipality issued PPO in her favor on 15/12/2021.
My death certificate given page 15. Death certificate given page 15, that is petitions. Annexure P2.
Full stop. However, the petitioner claims that he has still not received the gratuity amount of rupees 3,30,000 and rupees 1,02,096 towards arrears of pension. Full stop. Petitioner states that he had made representation before the respondent municipality, but the same have not been acted upon.
Representation made on 19/4/2025.
Being aggrieved, the petitioner has preferred the present petition. Learned counsel for the respondent states that the petitioner has already been paid the entire arrears of pension. And on, when was this last 50,000 paid? What is it?
50,000 paid sometimes in the month of June.
2025, the amount has been settled.
And an amount of rupees 50,000 towards gratuity has been paid in June 2025. Full stop. She says that an amount of rupees 2,80,000 is due to the petitioner for on account of gratuity. Full stop. The same is disputed by the learned counsel for the petitioner. Full stop. Learned counsel for the respondent seeks and is granted 3 weeks time to file a report by way of an affidavit. Exception to the same, if any, within exception 1 week, 2 week,
2 weeks.
2 weeks. List after 8 weeks. 8 weeks will be after vacation. 4th November. 4th November.
4th November. Sir.
In October, I can't make the court work, no?
I know.
4th November.
Month of life.
As you lodge. Final. Yes.
The appearing for the respondent number 10 and 11, my lord.
Yes.
I am appearing for the state respondent in item number 6, my lord.
The one who doesn't have to do anything speaks the loudest. Yes.
I mean, I make my submissions. My
My lord, your lordship rejected the sole authority to reply.
lord, the
Yeah, your lordship rejected the sole authority. They took time to give reply.
Let's hear them.
anyway, my lord, I have filed an application can 1 for vacating the interim order. My lord, I'll take my lord through the pages where the allegations have been made against state respondent number
Against that
10 and
application, I have prepared my affidavit in opposition, my lord, your lordship.
was my correction.
Yes.
If my lord kindly comes to page number 10, para 10 of the original writ application, item number 5.
Page number 10.
10, para 10. It says about the pendency of a suit instituted by the petitioner.
Yes.
May I, my lord?
Yes, Mr. Bandyopadhyay, you're here. Yes.
I'm here.
See, the entire allegation is it's a post facto approval. I'm sure you're.
It is not. We have taken instruction.
What is it?
We were under the impression that the earlier building will be demolished and a fresh construction will be made thereupon on the vacant land.
No, but
If they have made construction over a existing construction, it has to be pulled down and started afresh. That is the stand of the corporation. There is
Then
no
you find
power
that-
upon us, assuming an engineer has given post facto any building
So
plan,
then-
etc. It is non-est.
Then in that case, Mr. Bandyopadhyay, the affidavit which you have filed is not reflecting your stand at all.
No, my lord, that question, my lord, what is falling from your lordship today did not fall earlier, my lord. So the specific, but my lord, if your lordship sees the
That's not only the question falling from me. This is the entire averment in the writ petition. This is what they have stated in the writ petition, that it's a post facto approval
It
which
is
has
not.
been.
My lord, this
So-
can be
It's all right. If this is your stand, then we should not take this.
But we can only rebut it by way of an opposition. But this is a report.
Then you file.
It's a report. Your lordship will kindly consider that we have not dealt with every averment.
You file an affidavit.
Yes.
Dealing with every averment. We'll give you time. You file an affidavit.
Even the shortest possible time your lordship may give me, my lord.
2 weeks.
My lord.
Lordship, will be hearing for a question.
Yes.
I am not, the main allegation is against me. That I have obtained a post facto sanction. If your lordship will kindly come to page 9 of the petition, paragraph 9, what they have stated. That the respondent number, page 9.
Have you filed your affidavit?
No.
Did you seek a direction?
So just, I will show one paragraph and the sanction plan. Thereafter, your lordship will pass the.
Yes.
Paragraph 9 also what they have stated that the respondent number 8 along with the strangers having right at the interest in arrest brought by such and such. According their needs in the petitioner who claim to be advocate forcibly wrongfully illegal constructions in the aforesaid plot of the plot and the co-sharers of the plot and the submitted executive complaint. Here, lordship, what are the construction, lordship? The construction is shop rooms. What I have obtained, lordship, is a sanction plan of 2-story building. What my humble submission is that if there is a 2-story building, there is no allegation of 2-story. In respect of 2-story building, I will be permitted to make construction as per the sanction plan. If there is any deviation from the sanction plan, corporation will take steps.
Today, how have you constructed those shops?
Those shop rooms,
How have you constructed those shops which are there?
those shop rooms were there, lordship. There are.
How have you constructed? Where is the sanction plan for those shops?
Let it be demolished. I'm not to that.
So why don't you demolish it?
The permission
What?
to demolish.
What do you mean, do you-
Construction as per the sanction plan.
Who's stopping you? You go ahead with the demolition. Why didn't you do it? Who has stopped you from demolishing it?
Let me have construct.
If you are admitting that you'll demolish it, I'll pass an order that you'll demolish it and you'll construct in accordance with the sanction plan.
Kindly pass that order. I'm obliged. If there is any.
Mr. Bandyopadhyay?
Let them be compliant with the they have the sanction plan. Let them exercise their whatever resources they have. If they cannot, I'll bring my main and machinery.
While I stand on a different
My
footing,
my
my lord.
submission, when the shop room was constructed,
Sir, now forget whatever it is.
and
They are
that's why, my lord, in the,
They are admitting it's an illegal shop room. They are ready to demolish it.
yes, my lord.
Do you have any objection?
And my lord, regarding the sanction, my right to be reserved, my lord,
Right to be reserved for what?
regarding the issuance of the sanction.
Issuance of sanction means?
That is the.
Post facto, they are saying there's no post facto.
My lord,
They will construct in accordance with the sanction which has been accorded to them.
My lord, when they applied for sanction.
So that story goes.
All right, then, only, my lord, my legal remedy, I may be.
What legal remedy, sir? Your remedies are exhausted now.
My legal remedy that this is my land.
No, that we have also.
And my lord, there is an encroachment.
We are not in civil dispute, sir.
That
is the ultimate.
We are not deciding your civil rights.
Honor,
Whether it's your land, his land, whose land, we are not there to decide.
Because the civil court we have taken steps that.
Whatever you have to do.
My lord, I completely stand on a different footing, my lord. That is why I was submitting.
Yes.
There's no allegation of post facto sanction against me. Even the order passing the injunction, there was the submission was recorded on their behalf. Was stated 8 and 9. They had constructed as per a post facto sanction.
So are there different buildings?
Different properties.
So one
different
is
buildings.
8, 9, one is
10 and 11.
10, 11.
I have filed a application for vacating. My lord, kindly takes it up for once. I'll show my lord. Can 1 along with the item number 5.
And then I have filed my.
Just a minute, let me see.
So my lord kindly comes to page 28 of the that application, my lord.
The application is কোথায় পাবো আমি?
My lord, find a sketch map.
WP number?
Page 28.
My lord.
নতুনটা এইটাতে 1 2 3 9.
Yes.
That is a demarcated portion, my lord. Will kindly find from the top plot that I have purchased.
Which
They-
one?
The top one, my lord,
Part of RS Dag number 25 something.
my lord,
That's
the
one.
top plot,
250.
my lord.
Yes.
Now, my lord, it is demarcated plot. Their allegation with regard to unpartitioned land, my lord, that is taken care of. Now, subsequently, my lord, kindly comes to page number 32. Their allegation was I was constructing on a Shali land. Now, my lord, page 32
Yes.
is my conversion certificate to Bastu in 2016. Now, my lord, kindly comes to page number 33. That is my sanctioned building permit.
Yes.
I applied in November 2024, granted to me on 6th of January. My lord, there is no prior proceeding initiated by the petitioner against me. I am not party to the civil proceeding, criminal proceeding, or the writ application prior. Now, my lord, the plan is annexed with the CAN application, my lord, it's in my name, in the name of the respondent number 10. Now, my lord, kindly comes to the order passed by this honorable court on 3rd of June, page 39. The first paragraph.
Yes.
The present writ petition challenges a post facto sanction of a building plan granted in favor of respondent number 10 aimed at regularizing the construction.
Respondent number 9.
And now respondent 9, I am 10 and 11. Man, there's no allegation, there's not even a prayer in the original writ application against me. I have been injuncted. I have a sanctioned building permit, I have a conversion certificate, I have recorded my names in the revenue department. And my lord, one more thing, they have submitted before the.
What is your allegation against
My
10
allegation,
and 11?
my allegation against my lord, when they started construction, there was no building plan.
No, my lord, kindly comes to page 19.
Just a minute, sir.
Very well.
And my lord, I have also, my lord, stated that in plot number.
They have a different building plan.
My lord, my lord, in
Mr.
respect of,
Bandyopadhyay, that has not been dealt with in the report.
there is no.
No, my lord, your lordship will find. No, my lord, we have dealt with the other one.
Your lordship,
Only this one.
Yes, only this.
your lordship will asking me that in my writ application, we have specifically stated that in.
Sir, in your writ petition, where are you saying that they have a separate building plan?
No. We came to know when they filed vacating application.
Sorry?
When I came to know that they got the building plan in 2025,
Yes.
when they filed vacating application.
When they filed vacating application.
Vacating application.
So in your writ petition, there is nothing.
No, in my writ application, we have stated, you will also kindly consider my writ application, you will also find that we have also mentioned earlier that in respect of respondent number 9 and 10 and 11, we have mentioned earlier, you also will find paragraph my lord, you also will find
Yes, still. Page 19, my lord, kindly comes.
paragraph
Page 19, 19.
আরে আমাকে একটু বলতে দিচ্ছি
সাহেব বললেন।
my lord
Page 19, which is a
page-
continuation of
page-
para 10.
Page, my lord,
Eighth line from the bottom.
my lord, page 20, page 29,
That is the allegation against.
paragraph 23, you will also find at page 30, accordingly, the petitioner having submits that unless the issuance of the an order such and such, then before that, my lord, the specific allegation, paragraph 28, last portion will also find, and further acts of the said respondent are for not taking steps against the private respondents, aid to such and to demolish the alleged construction and of the shop room such and such, that in abuse such and such thing. And by those respondents, particularly private respondent number 10 and 11, who are also making illegal and unauthorized massive construction in plot number 254, which
No,
is
you were not even aware of his existence.
which is totally unpartitioned. This is a totally unpartitioned. I got my mighty share 1.10 acres. Undivided property.
That is why I showed the sketch map, demarcated.
That's why.
Page 30.
Mr. Bandyopadhyay, file your affidavit in opposition.
My lord,
This
in
will
that
not-
effect, I submitted a reported judgment of this honorable court.
May I
We
point
have-
out
we have
one
seen
more
all
thing, my lord? Page 39, my lord, kindly comes once. Last thing, my lord, I'll
See,
point out.
till the time the affidavit doesn't come, this
The
matter,
prayer doesn't not include me
you
even.
file your affidavit.
I have filed a vacating application. I'll
File an affidavit. You are a party here?
I am a party in the item number 5, not a 6, not in 6.
My lord, against that vacating
Item
application.
number 5, no? That's
Item
all
number
right.
5.
All the pleadings are in 5 only. Yes, none of the pleadings have been done in 6.
Lordship is passing an order of filing affidavit.
Yes.
Lordship will pass that order, Lordship, let me,
No, let the stand
Let
come.
them be put on some terms.
Let the stand come. You also file an affidavit. Let the stand come.
Let them.
now, since I am having an sanction building.
Sir,
You can try this.
4 weeks will not make any
No,
difference.
let them be put on terms, but that's they can let them be put on some terms, my lord.
What
At
terms?
the end of the day, if my sanction plans is corroborated by the KMC, my lord, I'll suffer for this entire period of injunction.
We'll see that. That's only at the time of passing the final order.
Well, I'll reserve my rights to pay for damages then, my lord.
You are most welcome to pay for damages. File a civil suit, get damages.
Their right was there to, they could have applied for under the right to information to for necessary information as to whether I have a sanction plan. They have not done a single
File
thing.
your affidavit, we'll see that.
That is why I filed the vacating application in the
vacating application, you should not have filed also.
One more thing, file a vacating application. They submitted before Justice Chatterjee that despite service, none appears on behalf of the respondent number 10. In my vacating application, I have given the postal track reports and the postal receipt to show that I received the copy of the writ petition after the order was passed.
All right, whatever you have to say, state it in the affidavit.
Well, I'll be
You submit it on record? On your affidavit, submit it? That we are ready to demolish admit it? Get it demolished? What's the big deal? Do it right now?
Let them be put on some terms. That's all I pray, my lord.
Terms, can I put it today?
My lord. Let them submit some sort of token amount before the Registrar General. They'll be able
today,
to.
Before hearing the parties, before deciding the matter. As an interim measure.
My bona fide is there. I am showing my sanction building permit, my lord, the conversion certificate. There are only allegations that I am constructing without a sanction plan, and
please don't make submissions which doesn't have any head or tail.
There are no allegations.
Let me hear the matter.
There's no allegation against me.
You said the repetition and you permit me if there is any illegal construction, I will do.
You demolished the illegal construction.
No, there was an injunction order. Therefore, if anything I go to do there, they will come before your lordship alleging violations.
All right, take down. You have filed your report today only, right?
No, my lord, we have filed it previously.
Today I have filed exception, madam.
क्या लिखा है? Taken. The learned counsel for the petitioner states that the report filed by the Vedanagar Municipal Corporation does not address the issue of post facto approval of the building plan. Full stop. It is the contention of the learned counsel for the petitioner that the corporation has sanctioned the building plan after the construction was completed or undertaken
through clustering and shutter door.
After the construction had already been partially carried out. Full stop. Learned counsel for the petitioner further states that the respondent corporation has no power to grant post facto approval of building plan. Full stop. Learned counsel for the respondent corporation states on instruction that no post facto approval has been granted and that the building plan has been sanctioned for raising fresh construction in accordance with the sanctioned building plan. Full stop. Learned counsel for the private respondent number 9 and 10, right?
10 and 11, my lord. I am.
No, not you.
8 and 9.
8 and 9 states that they had carried out some illegal and unauthorized construction prior to the sanctioning of the building plan. Full stop. They state that they will remove the illegal and unauthorized construction which has been carried out prior to the sanctioning of the building plan. Full stop. They state that they will make constructions only in compliance of the valid sanctioned building plan. Which page is the building plan?
24, 22, 2025.
Page 20?
Page, my lord,
Where is the sanctioned building
Well,
permit? Permit.
page 110.
But as far as 10 and 11 is concerned, it is in Can 1.
No,
Is it
8 and 9 is concerned.
P9, page 109.
10?
110.
Plan টা লাগাওনি বোধহয়।
It is sanctioned on 10/1/2025.
7th of
20th
December 2020.
Sorry?
20th April 2025.
Application 7th December.
20th April 25.
Yes, 20th April 20.
This page number?
Page 110.
110.
And the alleged sanction for residential purpose.
क्या लिखा है? Accorded on 20th of April 2025 by the Municipal Corporation, Bidhannagar Municipal Corporation. Full stop. Learned counsel for the private respondent number 10 and 11 submits that there is no averment in the writ petition regarding the post facto sanction as far as their property is concerned. Full stop. Where is your this thing?
Can 1 month.
When is your building plan sanctioned?
My lord, page 33, January 6, 2025.
Learned counsel further submits that he has a valid sanctioned building plan issued on
January 6, 2025.
January 6, 2025. Is there any construction there right now in the plot?
Right now, there's some construction since it was granted in January and interim injunction was granted to them in June. Some construction is there before the injunction order was passed.
How much construction?
I'm just requiring. The first ground floor is not even complete. Incomplete ground
He
floor.
states that he had undertaken the said construction. He had undertaken the construction on the plot based on the valid sanction plan, and that the said construction has been stopped in view of the stay order passed by this court on. When was the stay order passed?
3rd of June, 2025. Page 39.
In terms of the order passed by this court on 3rd of June, 2025. Full stop. We can allow them to construct in terms of the sanction building plan?
And I have specifically stated their construction is illegal. In respect of their construction, the plan has been, well, the municipal authorities have considered this case. The plan has been.
Have you challenged the plan? You have not challenged the plan, sir.
I have challenged. I got this. I shall file the supplementary affidavit and affidavit in opposition to that.
What supplementary affidavit you will file? Challenging the plan over here?
No. I shall file my affidavit, supplementary affidavit to that effect, that the alleged building plan also municipal authority without making any inquiry, this is unpartitioned property.
May I say, sir,
May I say something?
Yes.
Well, generally, in some matters, we have come for the authority to say that the plan is forged, etc., etc. Well, for the authority, I should not make this submission, but in this matter, what I feel, my lord, from the records, both the plans are before your lordship. Good, bad, indifferent, two plans are there. If they want to construct when the matter is pending, it will be at their risk and peril. So, my lord, so let them construct, because in my books, my lord, the plans are genuine.
Yes.
Their petitioner's case, as I have understood, from a very unbiased compass, is their land dispute. Let them construct at their own risk. If your lordship finds it is illegal, they will demolish it.
I have submitted my lord, for the timing, my lord, your lordship, the interim order has passed, may be continued, my lord, for the timing. Your lordship, can you fix up the date?
It is not a case
Short date,
where
your
the
lordship, can
building
you
is
fix up?
constructed will fall upon the petitioner's head.
You know, I don't know. He has also filed an application.
Right.
If he would have not filed an application, it would have been easier for the court.
My lord, I shall
Application
file my
only for
affidavit to that application.
Only for modification. I'll not press the application if necessary, my lord.
Why have you filed this application?
Since they have suppressed material facts, that's why, my lord. Otherwise, I would not have, my
I
lord.
have not supplied, I have stated everything.
Make the life of the court more difficult by filing these applications.
Let us make construction as per the legal sanction plan. It will abide by the result of this petition, lordship.
It will be demolished if the direction is necessary is passed.
See, when you file these applications, then pleadings have to be completed.
I understand, my lord. I'll withdraw the application with the leave of the court. If necessary, my lord, I'll withdraw this application.
You withdraw this.
Very well, very well, very well, very well. Kindly
Learned
record
counsel
the
for
on
the
instructions, my lord. My client is here on instructions.
learned counsel for the respondent number
10.
10 and 11. 10.
Only
Respondent
10
number
filed the
10 states that he does not wish to press can 1. The same is dismissed as not pressed. Yeah, the
States that we are under based on sanction plan and that the same construction is not
in view of the stay order passed by this court on 3rd June 2025. Full stop. At this stage, learned counsel for the you file your affidavit in 2 weeks. We'll dispose it off in 4 weeks time.
In the meantime, let us construct, my lord.
The
Regarding the, my lord,
I'll break it down myself if necessary, my lord.
in view of this, learned counsel for the respondent corporation seeks and is granted 2 weeks time to file his affidavit in opposition. Reply to the same, if any, within 3 weeks. Full stop. Learned counsel for the respondent number 8 and 9 seeks and is granted 2 weeks time to file his affidavit in opposition. Reply, if any, within 1 week thereafter. Learned counsel for the respondent number 10 seeks and is granted 2 weeks time to file his affidavit in opposition. Reply, if any, within 1 week thereafter. The interim order granted earlier stands vacated in view of the fact that the respondent number 10 in view of the fact that any illegal or unauthorized construction which will be carried out by this is for you're also constructing. I'll only modify to the extent of respondent number 10. Not
permit me to
the interim order. The interim order granted earlier by order dated 3/6/2025 stands modified to the extent qua only respondent number 10, wherein he is permitted to carry on his construction in accordance with the valid sanction plan Full stop. Counsel for the respondent, number 10, undertakes that he shall not deviate, he shall not carry out any illegal or unauthorized construction in deviation of the sanction plan. Full stop. Let this matter be listed on, give after 4 weeks.
My lord, regarding respondent number 10, my lord.
Yes.
The respondent number 10, my lord, will also be modified to the extent, my lord, they
They
may
can
be
carry on the
in
construction
accordance with law.
in accordance with.
And my lord, I may be permitted to deal with their alleged building plan.
That is, you have a right, you file a separate writ petition challenging all the building plans.
All right. My lord, you will also kindly clarify to that effect that I may be permitted to.
Why should I clarify, sir?
The
That is
liberty
a right
follows the-
available to in your, you challenge the sanction building plan.
All right.
But that's a separate proceeding.
All right.
Don't file a supplementary, I'll dismiss it.
But he will be hit by order to rule too. You cannot challenge it now.
3rd September, 3rd September.
Grateful, man.
And my lord,
Extremely good.
and my lord, the interim order in respect of 8 and 9 will continue, my lord.
The interim order in respect of respondent number 8 and 9 shall remain till they shall remain till the next date of it. I'm grateful. Until further, till for a period of 5 weeks or until further order.
Deep lovely.
You give an undertaking, I'm not recording it. I could have recorded in the order, but I'm not recording. You file it, we'll record it. I can that much liberty I can give you. You can remove your illegal unauthorized construction. You can if you can do it in the meantime.
In the meantime, if I do it, I will proceed with the.
Not proceed till the time you don't file. You file it, we'll see it. ये रख इसमें order down.
My lord, you are grateful to your lordship, my lord.
অনেক grateful. ঠিক আছে চল
হ্যাঁ।
Fine. Reply 1 week, no? 2 weeks on it, 2 weeks on.
I am for the petition.
Well, I make clear here on behalf of the Titagarh municipality, this is the admitted fact that I have not paid the
Gratuity and part payment of the provident fund. My lord.
due to my lord paucity of the fund, my lord knows the Titagarh municipality is suffering from my lord financial hardship.
All the universities are suffering.
We require some time, we shall pay, my lord. This is the right to my lord.
That we are facing it every day, sir. Every day.
Well, what happened, my lord?
All
Nowadays, Titagarh municipality, my lord, only depend
No,
upon
not only you.
property tax.
All
I'm
municipal.
not only talking about
All municipalities.
Titagarh. I'm talking about
What's the state authority for some
Kontai, Titagarh,
Bhatpara,
we are rich.
Bhatpara
We
municipality.
have fund.
Bhatpara,
Bhatpara, my client, my lord, on 48.
Rajpur, Sonarpur. You know.
Financial hardship is there.
Now I think I know more about Bengal than
This is the right to give, my lord, for
all
my lord,
your
gratuity and my lord and my lord, provident fund.
Take on.
We my lord, part
Depet-
payment made in
the
respect to the
petitioner.
gratuity, my lord.
But unfortunate provident fund amount has not been paid last 5 years, my lord. In case of private company, my lord, if the provident fund amount does not deposit, my lord, criminal case should be initiated against him.
Absolutely.
But this is a case, government employer is withholding the provident fund amount, my lord.
My lord, all jute mill and my lord factories are closed. That is the problem. We are not, my lord.
Municipality may be closed, my lord. Otherwise, there is nothing.
Immediately, my lord, I informed the chairman. My lord, chairman
Page 9,
requested me to pay.
gratuity 6 lakh, page 9, gratuity 6,27,000. No, no, কত টাকা বাকি আছে আমার? And page 10, prayer bid Provident fund amount dues 2,76,470. Page 9 and 10 in prior, I have categorically mentioned the amount dues.
We are trying to, my lord,
The
make payment by
petitioner has
installment.
preferred the present writ petition
কারো কাছেই টাকা
due
নেই।
to inaction on part of the respondent. This is corporation, municipal, Titagarh municipality in not releasing the gratuity amount of rupees 6,27,656 along with interest in favor of the petitioner as well as non-payment of provident fund of rupees 2,76,470 along with interest to the petitioner. Full stop. Counsel for the petitioner states that the petitioner had joined the municipality on 16th April 1989 and after rendering an unblemished service career of more than 32 years, the petitioner superannuated on 31/3/2022. Full stop. The petitioner received the PPO. Even after receiving the PPO, the petitioner has still not received his gratuity amount. Full stop. He further states that an amount of rupees 5,76,470 has accumulated to the Provident Fund account of the petitioner, out of which he has only received 3 lakhs till now, and the balance of rupees 2,76,470 is still remains unpaid. Full stop. He had counsel for the petitioner states that they had made several representations to the respondent municipality, but the same have not been acted upon. Full stop. Learned counsel for the respondent Titagarh municipality seeks and is granted 2 weeks.
Let it be, my lord. Let it be, my lord, 6 weeks, my lord. In the meantime, my lord, by installment, we shall pay, my lord.
4 weeks to file his affidavit in opposition. A reply to the same, if any, within 2 weeks. That makes it 6 weeks. At least start making the payment so that
We shall start, my lord.
So
But
at least
I assured my learned friend that we shall make payment. I already, my lord, talked with my chairman that some payment should be given before puja, my lord. I also, my lord, told the chairman.
list after 6 weeks.
In the meantime, let there be an order. In the meantime, some payment should be made.
Learned counsel for the respondent, Titagarh municipality assures this court that
Some part payment.
some part payment will be released in favor of the petitioner. Full stop. Uske baad kar dena. He seeks and is granted.
I shall
further time.
look into the matter personally because they are the pension holder. We are paying the pension regularly, but so far, my lord, Provident Fund and gratuity amount, my lord, the huge amount
You
is
are paying the
pending.
pension.
Pension he is receiving. He is
Lot of places pension is not being paid.
Also, yes. In Bhatpara,
Bhatpara.
pension is not going, receiving since March. After March. from
After March,
April.
they have not paid.
Not paid.
I deeply oblige.
After 6 weeks. That will go in, take a date, September,
September.
17th
করে দেবো।
September.
যতটা পারি করুন।
15-minute time for the petitioner.
For the state, my lord.
But kindly straightway come to page 42. A tender has been floated by Kishannagar municipality. I have
You are
participated,
appearing for?
My lord, I'm for the state.
Where is the municipality?
but I have served. That has been delivered.
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 देखो सर्विस हुआ है। Which municipality is this?
Krishnanagar municipality. Krishnanagar
Call the
municipality.
lawyer for the Krishnanagari.
Lordship.
You know the lawyer?
Lord, I have to collect the details.
Manoj. Manoj. Krishnanagar municipality का number दो. We'll have it on next week. Take down the number and name of the lawyer. है कृष्णनगर होगा.
Lord, I shall supply, my lord, if you need it.
Please give. We'll have it next week. Not today.
The deputy of service may be kept with.
Keep it back.
My lord, I'm for the petition. My lord, kindly take up, my lord, the two matters, my lord, item 16 and 17. Both are of the similar matter and with regard to, my lord, same subject matter, my lord, same building, my lord.
Yes.
My lord, your lordship was
16 and 17.
guided on other date of hearing to submit the resolution of the Board of Councillors. But I am submitting the same to before the decision was taken to demolish the building. According to notice was given, but he did not comply. This is the English version, also resolution of the Board of Directors.
Just take it. So now the final order has been passed. So both these petitions are infructuous.
My lord, no order has been communicated.
Sir, I'm giving a copy of the order.
Kindly give. My lord, in the second petition, my lord, there is one prayer, my lord. They are praying for considering the representation which has been filed by the petitioner, my lord, which is still pending before the municipal authority, my lord.
Now this order has been passed. Nothing survives in the petition.
My lord,
Take this order.
my lord,
Challenge the order.
My lord, kindly see, my lord, page 44, my lord.
Page 42 of the second writ petition.
petition, my lord.
You want an end to the litigation, I'll dispose it off with observations.
My lord, the petitioner raised the building under the compulsory.
Sir, order has been passed, rightly, wrongly, challenge it. All right. Today that is not under challenge here. You have come against the notice. After notice, it has culminated into an order. All right. So you want, I can dispose it off, which will close more rights of yours.
My lord, kindly give liberty to the petitioner to file to prefer an appeal and to condone the delay, my lord.
Learned counsel for the petitioner seeks to withdraw the present writ petition since the final demolition order has already been passed. A copy of the order is handed over to the counsel for the petitioner. He shall be at liberty to challenge the same in accordance with law. Full stop. In view of the said development, learned counsel for the petitioner seeks to.
My lord, this order doesn't bear the seal and signature. My lord.
Bengali order is there, and this is the English version.
Seeks to withdraw the present writ petition. The same is dismissed as withdrawn. Item 17, 6. The learned counsel for the petitioner seeks to withdraw the present writ petition. The same is dismissed as withdrawn. I go on the file.
Lordship, item number.
Both the matters are disposed of.
Both are disposed of.
Lordship, item number 15. On earlier occasion, I was present, but my name was not recorded, Lordship. As an estate advocate.
For the state?
For the state.
My lord, I am for the petitioner, my lord. My lord, this is against unauthorized construction, my lord. My lord, previously an order has been passed by this honorable court, my lord. That is, my lord, annexure P3, page 24. My lord, I don't find my lord. P3, page 20. Annexure P3, page 24, my lord. Passed by Justice Shina, my lord, Mrs. Justice Shina.
Yes.
My lord. By that order, my lord. My lord, the lordship has been pleased to direct the executive engineer to consider and dispose of the petitioner's representations on the allegation that it is a unauthorized construction and to take a decision in accordance with law. My lord, despite communication, my lord, this order was passed in presence of the, my lord, all the respondents. But despite communication, my lord, that has not been done, my lord. My lord,
Why don't you file contempt? You don't have a
my
system
lord,
of filing
contempt is something different, my lord. Your lordship kindly say, I have to satisfy this court that there is deliberate and willful violation.
There is.
My
The
lord,
order has been passed by this court,
my
not
lord, only
compliance
one
of
thing,
the
my
order
lord,
means
here what has
contempt.
happened, my lord, that executive engineer, my lord, did not receive the communication. And my lord, further I have write a letter to the commissioner. I requested him to send the notice to the executive engineer for compliance of the honorable court's order. My lord, what has happened, my lord, that has also not been done, my lord. My lord, subsequently, the post of executive engineer has been, my lord, they have.
Sir, how is this maintainable? You tell me, how is this writ petition maintainable? What are you asking for?
My lord, your lordship can always direct for implementation of the earlier order passed by this court.
What implementation of the earlier order?
Yes, my lord. That is only to consider the representation and to take a decision in whether there is unauthorized construction or not. If there is unauthorized construction, he has to take steps in accordance with law.
Who's appearing?
For the agency, my lord, led by Mr. Sanjeev Banerjee.
But why have you not decided it? The order has been passed.
My lord, in their presence, my lord.
My lord, Mr. Banerjee must having the instruction, my lord.
All right. When do you want? Monday?
Tuesday, my lord.
Tuesday. Not today, Tuesday.
Then 19th.
You please come up with the instruction.
My lord.
Comply with the order. Order has already been passed. Get the instruction, huh?
My lord, in this matter, I am for the petitioner. My lord,
For the state respondent, my
my lord, in the earlier occasion, my lord, matter has already been heard. My lord,
Mr. Vikas Ranjan Bhattacharya is appearing, my lord. Now he is in out of station. Kindly give me 19. On respondent number 8 to 17.
He is appearing for?
Item number 8 to 17. Respondent.
On 8 to 17.
Respondent. My lord, if you will also kindly adjourn this matter only for my lord, fortnight.
my lord,
But
kindly
these, now parliament is going on, and also, my lord, that DA matter is.
my lord, kindly peruse the earlier order. Matter has already been heard. My lord, 2 days fixed for the filing a report by the Howrah Municipal Corporation regarding the steps taken in connection of the illegal construction, my lord.
Yes, where's the report?
The report is Mr. Banerjee, my lord. Senior, my lord.
Where's Mr. Banerjee?
He is before court number 23, my lord. Huh? 30, my lord. 30.
So what are your instructions? The report has been prepared or not prepared? You need further time. What do you? Learned counsel for the respondent, Howrah Municipal Corporation, seeks and is granted further 2 weeks time to file his report by way of an affidavit as directed by this court, wide order dated 9/7/2025. Reply to the same, if any, within 1 week thereafter. List after 4 weeks.
My lord.
After 4 weeks?
After 4 weeks. Bye. Deeply obliged, my lord. Deeply obliged.
What state leakage?
ঠিক আছে
20 minute I am for the petitioner. But on the last occasion, your lordship was
I
pleased to
appeal for
direct
the
me
petition
to
respondent.
file an exception to the report filed by the municipal authorities. But this is my exception. I have already served the copy on the municipal authorities.
This is my lord with regard to the execution of the order of the special officer building by which my lord he.
But my
directed
case
to
is
the-
that a two-storied building plan, which is there in the report, the report says a two-storied building plan was taken and a five-storied constructed and fully occupied. But the report says it has been demolished partly and the rest of the part will be demolished. I have demonstrated in the writ petition itself, the photographs will show that nothing has been done and the building is still fully occupied. But the demolition, if any at all, this is absolutely some demolition, my lord, absolutely an eyewash. That your lordship will kindly consider. And my lord, for making a complaint, my client was assaulted. She filed a police complaint. Medical reports are there. Everything. Her office was ransacked. What not?
Where is your first report?
But a short report I find my lord was filed for the first time, possibly 9th of July 2025. It was with the photo. Former baby with the
no.
Well, possibly it was well handed over, but this is not in the form of baby David. And my land has such ticket. That is the report of 9 July 2025. But the decision has been taken by the authorities for demolition of the entire unauthorized construction as detected. Now it is to be executed. But there cannot be anything other than for demolition of that portion which has been detected and directed to be demolished.
For that, my lord, I have to knock your lordship's door, my lord. The municipal authorities will not do anything, whatever is required to be done by them according to law. They have taken decision after decision, but not doing anything.
Is this the first matter?
My lord?
Are you doing a demolition matter or against
No,
corporation?
The director has to give, submit an updated report and with the direction to expedite the actions, my lord, in terms of the order of the special officer building already passed.
So you had already sought time last time.
But last time the updated information has not come to me, my lord. That 9 July, my lord, the last order, last report was submitted to a losses court, my lord.
Yes.
I have not received the updated information.
Learned comes for the respondent, respondent Calcutta Municipal Corporation. Seeks and is granted. How much time, Mr. Ghosh?
Well, I request you, lordship, my lord, give me the 4 to 6 weeks so that, my lord,
You take some action.
6
6 weeks time to file the action taken report vis-a-vis the action taken report, full stop. Exception to the same, if any, within 1 week thereafter, list after 8 weeks.
But instead of, if your lordship keeps the entire matter within 6 weeks. After
See, demolition will never happen.
As the lordship.
You have
My
to-
lord, in this,
6 weeks
my
also,
lord,
you'll be
in
lucky.
this,
You'll be lucky if they would have done it.
I have serious doubts, my lord.
my lord, in this matter, I am
We'll have it after
appearing on
vacation.
behalf.
After vacation, we'll have it in 10th of November.
Grateful, my lord.
Take her Mary Datta.
Grateful, my lord.
10th of November.
Grateful.
But my exception may be taken on record.
Just add one line. Exception to the report filed by the KMC is taken on. Exception filed by the petitioners.
Deeply obliged.
21 is the response submission. It has become infructuous because of the order he is.
I think that is the reason he's also not coming. Nobody had appeared last time also.
Last time.
Just take down. This court notes that there was no appearance on behalf of the petitioner on 9/7/2025. Full stop. Today also, when the matter is called out, there is no appearance on behalf of the petitioner, full stop. It seems the petitioner is not interested in pursuing the present writ petition, full stop. The present writ petition is dismissed for non-prosecution.
নিচে দিয়েছে আচ্ছা শান্তনু নাম দিয়েছে তো? দিয়েছে শান্তনু 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 আমার জুনিয়র
I'm for the respondent number 1, the Asansol Durgapur Development
I am
Authority.
for the corporation, Durgapur Municipal Corporation.
Who's for the petitioner?
Should not represented.
Yeah, yeah. তো ইয়ের জন্য কৃষ্ণনগরের জন্য No, Banerjee is appeal.
Because on one occasion, accommodation was asked, prayed for him.
No, Shishana appear করেছিল
She appears, I think.
Shishana Banerjee was appearing, my lord. In any manner, my lord.
Not today.
Let it
None for
after
the-
দেখেছেন because
None for the
already, my lord,
peti-
it's
none-
a hearing matter. It will take some time.
None for the petitioner. Let this matter be listed on 4th of November.
আমি কোনো opposition দিইনি, আপনিও দেননি, আমরা দেননি।
Fourth.
4th of November.
Grateful.
वो ऐसे कर ये एक लाइन और ऐड करना है. None appears for the petitioner. In the interest of justice, adverse orders are deferred. Let this matter be listed on 4th of November.
I beg to appear on behalf of respondent number 225.
My lord, may I pray for not today? The advocate on record for the petitioner has a bereavement in his family. If the matter could be taken up tomorrow, your lordship.
Proxy counsel so and so, give your appearance. Proxy counsel so and so appears and states that the main arguing counsel has suffered a bereavement in the family. Full stop. She prays for a short adjournment. Full stop. Let this matter be adjourned to.
If it could be taken up tomorrow, your lordship, so that the matter can retain its position in the list.
Tomorrow.
Tomorrow is my lordship's original site.
This is not tomorrow's original site. We'll have it after 2 weeks. Give it after 29th February. 29th February.
Good.
What do you want? There's a hurry. There's a urgency.
I have nothing.
There's urgency.
I would kindly request your lordship, may the matter retain its position in the list, your lordship.
I have it on 12th of August then. 12th August.
I'm ready.
Part 24, I am for the petition. Today I am filing my reply. Just today, I have served the copy, my lord.
Mr. Ghosh is also filing. What are you filing, Mr. Ghosh?
Position already earlier filed, prepared and handed over to my learned.
Yes.
Today I am filing before the court.
Affidavit in opposition on behalf of the corporation is taken on record. A reply to the affidavit in opposition filed by the petitioner is also taken on record. Full stop. Yes.
আজ করবেন তো?
He has given me today, my lord. I have not seen, my lord, what he has written. Just now I have
Up
given
to you, Mr. Ghosh. You
only have
want to do
submitted
it?
one thing, my lord, that he might be, my lord, paying for, because I am to look into it, because
I have also filed an extension of
this is an issue, my lord. My lord, this is an issue, my lord.
Between both of you, if you want, I am here. Want me to hear?
Fixed up any day, my lord. as
Here
per
is
the-
short check this, because it's a 4-story complete unauthorized construction. I will go through it and you'll see passes an order, whatever.
Well, I shall try to satisfy lordship.
And only I will be
That
submitting to
they
the
have
lordship, my
sent a
lord.
notice in one name, but notice has been pasted in my house.
My lord, only
But I shall try to satisfy your lordship. It also-
my lord, only I am
Only
submitting
fixed up on any.
one issue to your lordship, my lord. He is saying that he is a occupant of a portion of the building. It's a 4-story entire building. The injunction, my lord, he cannot ask for the entire building. because he is concerned about the portion in which he is residing or occupying. Therefore, Your Lordship clarified that the interim order, if he earlier enjoyed the interim order was granted by the court. Now he is coming with an application for extension, reimposition of the interim order, because that stood vacated already.
So let's have it next week, Mr. Ghosh.
As your lordship, please, as per your
Now
lordship,
then-
convenient date, your lordship.
Next time, I will not do anything, but if the matter is taken up the next week.
Rather than complicating it, let's
My
have
lord,
it.
my lord, as Your Lordship, please.
Keep it next week, then we'll list on. Huh? 13th कर दें? 13th.
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 13th, my lord.
Yes.
As your lordship.
Lucky 13th.
Lucky for whom?
We'll see that.
Maybe lucky for us.
ये फाइल में डाल. Yes.
And for the state also.
I have 10 or 25. I am
Private resource.
For the petition also. This is regarding.
My lord, there was an order, my lord, of my affidavit in opposition, my lord. May I file it? My lord?
slipped and event.
May I get a copy of the?
Yes, yes. Brother.
You are appearing for?
The private response.
Private. And
for the state.
I'm for the municipality.
Sonarpur, which one?
Rajput Sonarpur.
Sonarpur. Where's your affidavit?
Lordship,
Direction is here. Respondents.
the private respondent seeks the affidavit. That is the issue. Lordship, issue is that the dispute between the owner and the developer. The municipality cannot be party in this matter. This private dispute, and as per section 218 of the Municipal Act, Lordship, whatever illegal or in contravention of the rules and sanction plan has been raised, the construction, the municipality will issue notice upon the owner, not the private respondent, the developer. There is your lordship, kindly see the section 218, lordship.
It is owner, occupier, or any other person.
No, lordship, in this section 218, only in respect of the owner, lordship.
My lord, he is alleging illegal construction, my lord. My lord, kindly, my lord, seize the apartments.
218. Order for
218, lordship.
Yes.
Subsection 1, then lordship A, B, C, lordship, it may, after giving the owner of the building a reasonable opportunity of being heard, make an order directing that such erection, alteration, addition, projection as case may be, or such much thereof as may be executed unlawfully, be demolished, alter upon such order, it shall be the duty of the owner to cause such demolition and alteration to the satisfaction of the Board of Councillor within the stipulated period as may be fixed in this behalf. In default, such and such. Lordship, there is no such provision. Here, the dispute between the owner and the developer, the municipality is not party in that agreement. Municipality cannot take steps against the private respondent, lordship. Whatever notice has to be issued for in contravention of the construction sanction plan, that will be issued in name of the owner, lordship.
Lord, kindly see the section 204, my lord, of municipal tax.
Just. What is the definition of owner? The definition of owner is, owner includes a person for the time being receiving the rent of any land or building or
Is
any
owner
part
account
of
agent. trustee, person of society or any religious charitable purpose as receiver who would receive such rent as if the land or building, any part thereof, land building were let out to a tenant.
If you add owner and occupier, the definition of owner and occupier, you can extend it to any person.
Lordship, your lordship.
Read occupier. Occupier includes
includes
any
any
person
person
for the time being paying or liable to pay the owner the rent or fee or contractual payment of adjustment of rent or fee or any portion thereof or damages on account of the occupation of any land or building, provided that an owner living in or otherwise using his own land or building shall be deemed to be the occupier thereof.
Lordship.
Then if you read that with the word owner, owner includes the person for the time being receiving the rent of any land or building or any part of land or building.
Lordship.
So that will
Receiving rent.
extend to owner and occupier both.
In this
218.
particular case, lordship, there is a developer and there is no relation with the.
That is fine. What were you saying? 200.
File the report, my lord, on behalf of the special secretary.
You appear for state.
Yes.
All right. What is your case, sir?
Well, this is regarding illegal construction, lordship.
Illegal
lordship,
construction.
for sure.
Who is raising the illegal construction?
So private respondent, lordship, without may submit.
Who are
private
you?
respondents.
You
I'm
have
the landlord,
agreement.
lordship. I'm the
You are
landlord.
the landlord.
Lordship.
You gave it to
Private respondents, lordship, for development, lordship.
private respondents.
For development, lordship, without completion certificate, lordship, they have sold off all the flats.
Very good.
Without giving me possession.
What is the illegality?
Lordship, lordship. Paragraph, lordship.
Your personal private disputes are not amenable to writ.
The private dispute, lordship, without CC's, lordship, without issuing completion certificate, they have sold off all the flats of the
Very
property,
good.
lordship. The
Go
municipality is
after
saying,
him.
lordship, I have nothing to do.
Go after him.
Lordship, let there be deduction, lordship, municipality to issue completion. Let them give completion certificate. You have
But they
nothing to do, lordship.
Are you asking for completion certificate?
Lordship, if
Never applied
why
for.
so? Why
What are you
so?
asking for? What are you asking? Tell
Lordship,
me. What are your
My
prayers?
prayer number 6, lordship. This is what I'm my grievances,
What is your first prayer? Come to the prayer.
lordship. For inquiry, lordship, that is the thing. My
Legal
lordship,
proceeding against the private respondent.
Against private respondent.
lordship, prayer number 6, if your lordship kindly takes a look, lordship. No electricity there, lordship, in my room. No possession certificate, no electricity, no completion certificate.
Private respondent is a party here.
My lord, I'm for the private. My lord, kindly, my lord, see.
Just a minute, just a minute. So you are the owner of the land, enter into a development agreement,
Lordship,
right?
lordship,
They are the developers.
they're the developers, lordship.
Yes. Now you are not getting your money, so you have filed this case, right?
Lordship, my
Now, yes, tell me.
My lord, kindly seize, my lord, the averments in the writ petition. All the averments, my lord, relate to the development agreement. The clause of the development agreement, my lord, not being followed. He was, my lord, being promised to, my lord, make certain amount of money. That was not, my lord, given to him. After that, my lord, certain portion of the position was, my lord, it was promised to him. That was not given to him. These are, my lord, kindly, my lord, takes a my lord, paragraph number 5 onwards.
Yes.
lordship, paragraph number 20 is the
5
variation.
onwards, my lord, kindly, my lord, takes a paragraph 6, 7, 8, all the, my lord, paragraphs, my lord, relate to the dispute, my lord, with the private respondent, my lord, relating to the development agreement. My lord, nowhere, my lord, in all these paragraphs, there is not a single, my lord, scrap of, my lord, allegation, my lord, against my illegal construction. It goes up to, my lord, paragraph number 20. In 20, he says, my lord, kindly takes up, my lord, 20. Kindly, my lord, takes up 2020, he says, my lord, shop number 1 is converted into two parts, 1A and 1B, which are transferred to third party. It was, my lord, supposed to be transferred to him. Rather than my lord transferring to me, it has been transferred to a third party. Shop number 2 belongs to the owners. Car parking space number 1 has been divided into 2 parts. Part 1 is converted into a shop. My lord, these are the kind of allegations, my lord. Kindly see.
Yes, these are the illegalities. Electric room, caretaker room has been converted.
Car parking space belongs to the owner.
What are your instructions?
Lordship, the proceeding may be initiated against the both owner and private person.
Why should proceeding be initiated?
Lordship,
Have you-
after that,
What are your instructions?
the Lordship, the building plan was
Is there any
expire in the year 2024, Lordship, and they have not applied for completion plan.
But has the building been constructed in accordance with the
No,
sanction?
Lordship, as on date, that has not been inspected unless and unless they submit the completion plan. Then at the time of completion plan, the building will be inspected, but they have not submitted. This is the complaint. On basis of the complaint, municipality will inspect, Lordship, treating this writ petition as complaint, Lordship, then the irregularities will be detected.
Well,
And
DPT
the
representation
proceedings
made to
will
the
be initiated against the owner.
representation we made to the municipality for taking steps, Lordship. Did not prefer to take any steps, Lordship, till date.
Just take down. The petitioner has preferred the present writ petition alleging illegal and unauthorized construction being carried out by the private respondent. Where is the description of the property?
Description of the property.
Private respondent.
Paragraph number 4, Lordship.
In at jail number 34. Towsy number 281, LR Dag number 1027, LR Khetan number 140, PS Sonarpur within the limits of Rajpur Sonarpur municipality having municipality holding number 448 situated on RNC Road, Ward number 21, District South 24, Parganas. Full stop. The petitioner states that they had entered into a development agreement with the private respondents on 26th of May 2018 for construction of a, what is this? Multi-storied, what is it?
G+3, Lordship.
Multi-story building, my lord, to a flat.
For construction of
Residential flats.
For construction of multi-storied flats. Full stop. He states that the private respondents have illegally have deviated from the sanctioned building plan and have carried out illegal and unauthorized construction on the above said property. Full stop. He states that he had made various representations before the respondent Rajpur Sonarpur municipality, but the same have not been acted upon. Full stop. Learned counsel for the private respondent states that the present writ petition is not maintainable since the petitioner has filed this writ petition alleging breach of terms of the contract, alleging breach of terms of the development agreement entered into by the petitioner and the private respondent. He further states that the nature of dispute is he further states that it's a private dispute between the petitioner and the private respondents, and that the same is not maintainable. Full stop. Be that it may, since the petitioner has alleged illegal and unauthorized construction in violation of the sanctioned building plan, this court directs the respondent Rajpur Sonarpur municipality to file its report by way of an affidavit within a period of 3 weeks. Reply to the same, if any, within 1 week thereafter. Affidavit in opposition kar do 4 weeks, 2 weeks, 6 weeks.
My lord, my affidavit in opposition, my lord, be kept in the record.
You have already filed?
Yes, my lord, filed today.
The affidavit in opposition filed by the respondent number 456.
Are you given 2 weeks time, Lordship,
taken
to
on
file reply?
record. Learned counsel for the petitioner seeks and is granted 2 weeks time to file his reply to the said affidavit in opposition of respondent number 456. List after 8 weeks, November.
Lordship, just one prayer, Lordship. May I get a copy of the report filed by the state, Lordship?
My
You have
lord,
not
that is the
filed any
inspection,
report?
not a report, my lord. I've already filed.
What is this?
That is the inspection, my lord. Special secretary give the instruction to the chairman municipality. A matter between the chairman and the municipality. That is not the report, but the instruction. Last page of my report, my lord. Kindly see, my lord. Ekdom last page, my lord.
Now he's saying report, now he's saying.
Last page of the instruction, my lord. Give the necessary instruction to the chairman, my lord, to act as per extent the provision of law. Last page.
You take it back, give your appearance. Give it back. Don't hand over instructions like this. If you want to file a report or affidavit, file it.
Okay. Develop.
Both of them.
Well, may I file my affidavit of service?
Affidavit of service filed by the petitioner.
Develop.
What happened, I should not say. When I went there to, I went there.
Private respondent.
But this
At
matter,
my instance, a demolition order has been issued.
may I just, I'm the petition.
I am the corporation.
But kindly see the order passed by Justice Chandra Menon. What happened, Menon? Initially I have a sanctioned building plan G+3. Thereafter, Menon, I made the
Yes.
Number eight, initially I have a sanctioned building plan G+3. When I was to complete the construction up to G+3, but I took the shelter of my chartered engineer. He said I can make over construction. I started construction. I applied before the municipal authority. But they have, after considering, they made the searching, and they, after considering that the structural stability, grant sanction up to another 2 floors. Now at the present, I have the sanctioned building plan G+4 story. Now what happened? The private respondent here, who used to reside in Hooghly, and this construction is at Howrah, has no role. Number, I should not say in open court what is the reason. He filed a writ application before this honorable court on the basis of a RTI or on the basis of a complaint that I am making unauthorized construction. He moved before this court. Justice Shogata Bhattacharya was kind enough to direct the municipality to consider the application and dispose of the proceeding under section 177. Now, on that proceeding, I participated. An inspection was held, my instruction, no notice was given, but in the hearing, I have submitted all the building plan and I have also annexed. But if you see once, the building plan that I have annexed, at page 14, 1/4. This building plan is G+5 stories. And kindly see the back side, that has been approved by the corporation in the year 2017. And you see the back side, the corporation seal is there.
This is not at all a sanction.
May I just complete? I know. Sir, आपने तो very well said. Now, I was directed to pay the sanction fees, rather like extra 2 floors. But your lordship will kindly turn to page page 23.
Page
23. The corporation, for the purpose of second sanction, asked me to pay a sum of 20,91,336.
Yes.
Now that amount I have paid, at page 22 by check. Now what happened, when in terms of the order of the coordinate bench, when hearing took place, I submitted all these documents that you have already sanctioned the plan. Now, unfortunately, the impugned order is at page 20. Your lordship will find annexure P5. Nothing has been, it is a cyclostyle order. Nothing has been considered that the corporation has sanctioned G+6 also. They have already taken the amount, the demolition order has been passed. Neither inspection has been mentioned, nor, they have discussed that I have already sanctioned plan, nothing. This is a cyclostyle order. Now, first of after getting the sanction fee, how they can write this unauthorized?
You have attended the hearing on 2/12/2024.
Absolutely, I have attended the hearing. I produced all the documents.
Yes,
Yes, I have attended. I'm sorry.
And have admitted in writing.
That is absolutely false. That I have stated on oath. But I am on oath, I have stated. Kindly see page 6, paragraph 14.
Where is the demand for this 20 lakhs?
My lord.
Yes, my demand for 20 lakhs, your lordship will kindly turn to
page 23.
Page 23.
No,
24. 23, 24, 25.
Demand for what?
Sanction, my lord.
Retention fee.
Retention, sanction. Page 25, kindly see. Revised plan. Page 25. Revised plan issued by order number of the commissioner and the mayor. Now, my lord, kindly visualize who is the private.
Device claim issued by order. Jama.
All this thing has done in 2015. Now, my lord, with some, I should not say, my lord, with some intention, my lord, this private respondent who used to reside in Hooghly, kindly see his address, how he became, my lord, affected if the construction is made at Howrah. Kindly see his address, my lord, once.
Today we are not on that. That issue has already been dealt by the earlier.
Justice Boshak, my lord,
earlier
has already dealt, division bench. Now, my lord, the question is that, my lord, when I have a sanction, that's why Justice Chandra asked the corporation to file an affidavit.
So what is this page 26, 26 lakhs, 14,000, retention fees, 20 lakhs, commercial charges, 5 lakhs.
At 20 lakhs, 91,000, page 25, 20 lakhs, 91,000, my lord.
No, what is page 26?
26, my lord, 20 lakh 39,000, then commercial charges. Now thereafter 26 lakhs, my lord, I have filed an application that this is not for commercial, my lord. They reduce, my lord, to 20 lakhs 91,000, and I have paid that amount. Now the question will be before your lordship, my lord, first of all, when the corporation authority passed the order, impugned order at page 20, whether the corporation has considered his own record. This will be my first submission. Second submission, that the Justice Bhattacharya, the coordinate bench, directed to take steps in accordance with law. That means there must be an inspection, there must be they have to supply the copy of the inspection. And second thing, when they have admittedly, my lord, accepted the building plan, on what basis they are now saying in 2025 that your construction is unauthorized, 4th and 5th floor. Admittedly, I have the sanction building plan. And that's why, my lord, if your lordship see once, my lord, the order of the coordinate bench of Justice Chandra asked Mr. Banerjee for Howrah Municipal Corporation to take instruction and file a report or affidavit, my lord.
Yes.
Today is the date fixed for filing of, my lord, the affidavit and the report. My lord, kindly visualize how the private respondent is interested, my lord.
Yes, Mr. Ban.
Pension fees we have accepted.
Affidavit,
No doubt in this. So far as page 17 says.
So if you have accepted the retention fees, then why that is not reflected in your impugned order?
Yeah, I'm saying one. Page 17 is the order of the honorable court administrator.
Yes.
That has been said that after hearing the advocate representing the so and so.
Yes.
This court directs the concerned authorities of HMC to initiate a proceeding under section 177 of the Howrah Municipal Corporation with a period of 4 weeks from that date of communication of the order and conclude the so and so. However, it is made clear that passing final order of culmination of the proceeding to be drawn up, opportunity of hearing should be given. Order to be passed by the concerned authority, HMC shall be communicated to the petitioner. We have done everything regarding 177. At the time of hearing, I have submitted that I have taken the retention fees, but still the honorable court directed me.
No, my lord, this is not. This is not. Kindly
at least submit, then you will deny. The honorable court directed me still to pass an order regarding after on the basis of 177 proceedings of the Howrah Municipal Corporation. We have submitted that, and thereafter the order has been passed. Thereafter, we have passed the order. And so far as the page 20,
So why have you taken the retention fees? Please educate me that why are you charging this money? For what?
At that point of time, 2015, I will say that was not right thing. But I cannot say officially that. I was not at that point.
You have to file a report and say that why have you taken the retention fees? You have not considered that this order will go.
That is your lordship.
Yes.
Taken. Admitted.
Your lordship has seen the order passed by the other person in my writ petition, page 16.
Yes.
Your lordship, kindly turn the page.
Yes.
There is a specific direction despite hearing all the submission which has been adjourned by today.
What suppression?
Just a minute.
No appeal has been preferred against this order. They have accepted the position. They participated in the hearing.
Yes.
They will also kindly come to the demolition order. After providing opportunity of hearing, which will appear from page 19. This is a notice issued to all.
Yes.
In terms of the court's order. Page 19.
Yes.
Now pilot page 20. inviting reference to the action subject as cited above. This is to inform you that you have sanctioned plan of G+3. So construction has been at 2 additional floors, 4th and 5th.
Yes.
My learned friend also placed before your lordship an alleged sanction plan. If you lordship kindly take up the same reverse page, there is no sanction.
See, all that has to be dealt by the.
And so far the deposition of money is concerned, as I understood, my lord, anybody can deposit money at any time. There is no requirement to issue a notice, make payment of the same.
No, but no, there is. There is. In this case, there is.
If you lordship kindly come to the
Please come.
acknowledgement which has been placed before your lordship.
If first you come to
Page, my lord, 25.
Page 25.
My lord.
Yes. The revised claim issued by order of Commissioner and Honorable Mayor dated so and so, previous letter so and so.
Well, this does not say it. It is for the G+5.
But sir, this is they are making the statement that it does.
Yes, what I have
Or not
said,
for the corporation.
revised plan, maybe my lord, it was initially maybe my lord G+2, revised plan for G+3. Because ultimate
So,
sanction
Saria,
is
I would have accepted your contention if you were appearing for the corporation.
no. What I am saying, my lord, just minute, my lord. Sanction is G+3 subsequent thereto.
G+3 was
G+3
sanctioned
after 2015. Kindly take note of, my lord. After this additional fees, according to my learned friends, had there been a requirement to make further payment for further sanction, it should have been, my lord, G+4 or G+5. The sanction has been given in 2017 after taking this money for G+3. My
You are saying that the entire construction initially which was carried out was without any valid sanction plan.
And subsequently, my lord, this has been done and sanction has been granted. Kindly take note of 2017 after receiving all this money.
They will clarify that.
But because my lord, they have not annexed the sanction plan. In my writ petition, I have annexed the sanction plan. My writ petition is also pending for implementation of the order. It will have to kindly take up both the matter accordingly.
What is the repetition number?
But corporation, while considering, has not considered at all any document.
The only thing is that, my lord, sanction has ultimately granted, my lord, in 2017, when all this money has been deposited.
What is your stand? What is your stand? What is your stand on this sanction plan? It is a sanction plan?
Well, my WP number
Yes, sir. What is your repetition number?
15450 of 2025. WPA. 15450.
Just take down Kamal. The repetition number that you have taken down. Take down. The
But 1 week
petitioner-
time may be given for submission of report.
Sir, 2 weeks.
Why, how he is affected if I put this question to myself?
That has been settled by Supreme Court up to Supreme Court. Why?
You are only seeking consideration of your representation.
No, second, my lord, kindly see. Because my lord, after this order, I filed an application.
They will consider your representation.
Ad interim order was stay of operation of the order.
They will. I will stay that operation till they consider your representation.
Subject to your lordship consideration, since already an coordinate bench passed an order to initiate a proceedings and
Because
kindly see the order passed by Justice.
why I made this prayer?
By justice?
Page 16, page 17.
Yes.
Second paragraph. After hearing the learned advocate representing the petitioner,
Yes.
private respondent and the Howrah Municipal Corporation, this court directs the concerned authorities of Howrah Municipal Corporation to initiate a proceedings under section 177 of the Howrah Municipal Corporation Act within a period of 4 weeks from the date of communication of this order and conclude the said proceedings within a period of 16 weeks from the date of communication of the order. However, it is made clear that the before passing the order, so there is a mandatory direction to conclude the proceedings. But
That's
that
all
proceedings has been concluded.
That's
He
all
has
right.
not challenged this order at
That's
any
it.
stage, my lord. He participated in the proceedings.
Ah.
So he accepted this position so far the order of the court is concerned. Today, my lord, if you have to direct the concerned authority to consider again, possibly like it may.
I can do that. If you want me, I can remand it back.
But your
I
lordship,
can remand it back.
the corporation has not considered anything.
I can remand it back on the ground that they have not considered the retention fees.
Subject to lordship consider. Again, I am submitting, I am repeating rather, my lord.
See, Mr. Sari, I leave it to you. I can do both. I can call for a record where you have
Call for a
created,
record. Call for a record.
then I'm going to stay the order.
But I think
The stay has
Already
been
stay
done.
is there, my
It
lord,
is already
for
there.
limited period, my lord. Kindly extend the
We'll
time.
extend.
in any manner,
No, because Mr. The problem is I can always set aside the order. I can remand it back on the ground that these aspects have not been considered for a fresh hearing and in compliance of the direction passed by the.
I'm requesting your lordship kindly short for a report, because my specific case is that after
No,
receiving
how
all
he
these,
is his case?
A minute.
after receiving all these monies, since the plan has been subsequent to after
You
2
have
years-
given a new twist to the entire thing.
No, I am not on that. On
You have
2000
given a new twist.
No, no, no.
You have given a new twist to the extent that, that earlier building plan is not there and whatever has been considered,
That's a question, because he has not annexed the sanction plan. In my petition, I have annexed.
that they will answer.
It is 2017. Kindly take note of the date. If that is so, my lord, the money has been deposited 2015 and sanction has been granted 2017. Definitely, they have taken note of the same.
We'll see that. Then that report
Let
has
us submit a report.
in any manner, if I file a report, I cannot improve my case regarding annexure P5. I can.
Out of mutual
That
corporation.
has not been.
I must file a report in
No,
that.
you have to file a report to the extent of what he is saying. See, if it is what he's saying is correct, that the initial sanction plan was G+3 and subsequently they have constructed additional floors. And for that you have taken retention money, then it's a different case altogether. Then his submission, he's out.
This is my case.
But this is his case. But what he's saying, if it's correct, that there was no sanction plan and they constructed without a sanction plan,
Yes, yes.
and then you had taken money to regularize those 3 floors and the rest are remain illegal. And there's no retention paid for them, but retention is paid for the initial. That's his.
Kindly record his submission. If ultimately my case is proved,
Why
kindly-
he is not annexing the sanction plan?
he has already annexed. Kindly see.
This is not at all.
That they will answer. But you got the point.
Hmm.
Monthly to what number? My matter is appearing as monthly list item number 2786.
2786.
2786 WPA number 15450 of 2025.
Is it already listed or you've just filed it?
My lord.
Already listed.
Already.
7 minutes. Serial number is saying.
Just take
Listed it as
WPA number. All right. The petitioner has preferred the writ petition, seeking setting aside of the order dated 9/1/2025 issued by the assistant engineer in charge of building department, Havra Municipal Corporation. Full stop. Learned counsel for the petitioner states that this is the second round of litigation. Initially, the private respondent had preferred a writ petition number WPA number 10479 of 2016, wherein they had alleged unauthorized and illegal construction on part of the petitioner, qua property number, qua holding number 2/1, Bhajanlal Lohia Lane, Ward number 13, PS Golabati, Havra. This is the address?
Yes.
All right. A coordinate bench of this court, by order dated 15/1/2024, disposed of the writ petition directing Havra Municipal Corporation to initiate a proceeding under section 177 of the Havra Municipal Corporation Act 1980 within a period of 4 weeks from the date of communication of this order. And
16 weeks.
ये कर लो, यहाँ से tick to tick उठा दो. Page 17. The said writ petition, with the above direction, the said writ petition was disposed of. In terms of the direction passed by the coordinate bench, by its order dated 15/1/2024, the Havra Municipal Corporation passed the impugned order dated 9/1/2025. Full stop. It is the case of the petitioner that at the time of passing of the impugned order, the directions given by the coordinate bench while its order dated 15/1/2024 were not adhered to. Full stop. Learned counsel for the petitioner states that the petitioner had a valid sanction plan for G plus 3 floors. Full stop. He had constructed beyond the said floors based on the report of the structural engineer. He had constructed how many floors more? Two more floors above the said sanction plan based on the report of the structural engineer. Full stop. He states that he had deposited an amount of rupees 20,91,336 towards the retention fees as claimed by the corporation. Wide. It's letter dated. What is the date? It's in Bangla. Tell me.
19 June 2015.
19th
June.
June 2020.
2015.
2015. Full stop. He states that at the time of passing of the impugn order, the assistant engineer building failed to take note of this aspect and has not stated anything regarding the retention amount which has been deposited by the petitioner in terms of the unauthorized construction, which stood legalized according to him by acceptance of the retention money. Full stop. Learned counsel for the respondent municipality states, Havra municipality, Mr. Sandeepan Banerjee seeks and is granted 4 weeks time to file his affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter. Full stop. Learned counsel for the private respondent controverts the argument advanced by the learned counsel for the petitioner by stating, by short leave, yes, by learned counsel for the private respondent by stating that the petitioner did not had a valid sanction plan at the time when he had undertaken the construction of G plus 3 floors. Full stop. He further states that the corporation had taken the retention money for regularizing the G plus 3 floor, which were constructed illegally by the petitioner. Full stop. He further states that the additional floors, the 2 additional floors above the G plus 3 structure are illegal and were never regularized, and that the corporation had not accepted any retention fee for the above 2 floors. Full stop. He seeks and is granted 4 weeks time to file his affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter. Anything else?
No, I'm paying for 2 weeks time, not 4 weeks.
Let it be.
And my matter will appear along with this matter.
Yes.
WP number.
The learned counsel for the private respondent further states that he has filed WPA number so and so for seeking implementation of the order passed by the coordinate bench in WPA number.
No, but he has filed that it
by order dated so and so. This is what you're seeking.
Yes, yes. Yes, yes. Implementation of the order dated 9 January 20.
WPA number 1410 wo jo nahi hai?
Corporation order bolo. Judge Sahib likhchen High Court order.
No, my writ petition is
15450 is the writ petition which he has filed. Learned counsel for the respondent states that he has preferred a writ petition seeking implementation of the order.
January 2025 passed by the assistant engineer, Howrah Municipal.
Seeking implementation of the order dated 9th of January, so and so, passed by the assistant engineer, so and so, in terms of directions of the honorable court while it's order dated so and so, 15 January so and so, in writ petition number.
WPA 10479 of 2016.
Okay.
I
Both,
kind-
let both the matters be listed.
I kindly extend the interim order, my lord.
Yes, interim order granted earlier. Till when is it?
3 weeks it has been granted.
Interim order granted earlier is extended further for a period of 10 weeks or until further order, whichever is earlier. Is extended till, I'll give you a date. After vacation
Yes, sir.
is extended till 15th of November. Matter to appear on 4th of November.
Great.
4th? Good. Rest of the matters tomorrow.
Yes. I'm good. Updates yesterday.